Well, it's 3:00. We do have a bunch of preliminary matters we can start with, and hopefully Mr. Santeller will join us. So since we have all of our commissioners, I will be calling this meeting to order of the Wisconsin Election Commission. I'm going to call the roll. Commissioner Bostelman?
Here.
Commissioner Glancy?
Here.
Commissioner Knutson?
Here.
Commissioner Spindell?
Here.
Commissioner Thompson?
Here.
My name is Ann Jacobs. I'm chair of the Wisconsin Elections Commission, and we are here for a special meeting. Administrator Wolf, was this meeting properly noticed?
Yes, today's meeting was noticed in accordance with Wisconsin's open meeting laws.
Excellent. So today we have two agenda items before us. The first of which is ballot access and challenges for independent candidates for president and vice president. And we also have approval and denial of HAVA security subgrants to various counties. We're going to begin today with consideration of the challenges to ballot access for the independent candidates. I'm going to briefly outline today's logistics so that everyone knows what to expect. As to the challenges, each side will have 10 minutes to present their arguments to the commission. Administrator Wolf has agreed to be our timekeeper. We've asked the parties to select one presenter to allow us to focus on their arguments. Additionally, we have asked the parties to use the Bates stamped page numbers of the petition and other materials that we posted on our website, and not to refer to petition page numbers so that we all can know what everyone is talking about. Members of the public who want to take a look at the materials being referred to can go to wi.elections.gov, and in the middle of that page, about halfway down, under 2020 Wisconsin Election Information, click on General and Presidential Election November 3, 2020. You will find links to the materials there. The commissioners have been provided with copies of all approximately 1,600 pages of the materials submitted by the challengers, as well as digital copies of the media. The commissioners, in addition, have received various public comments in writing that have been submitted. We will not be having live public comments today. We will, however, hear live public comments at our September 1st meeting. However, persons who wish to speak live at that meeting will be required to register ahead of time because we're doing it by Zoom. And we will post more information about how to do that when we post the materials for that meeting. Today, the commission will be addressing all challenges made by the different parties, even if one of those challenges is dispositive of a candidate's access to the ballot. Commissioners will have the opportunity to question both the challengers and the respondents, and this will be in addition to any presentation made by them and will not affect their 10-minute time limit. Our staff counsel, Nate Jugnick, will then present the staff recommendations and will be available for any questions from the commission. And then finally, the commission will be entertaining motions as to those challenges. Finally, after the challenges are addressed, we will be having some final motions as to ballot access for any of the parties not addressed in the challenge process. We'll begin today. Do we have Mr. Santeller present?
It does not appear he's joined at this point.
Can somebody make a call to him?
Why don't we begin then with the Brent Hughes Smith and Stephen challenge versus Kanye West. The staff analysis begins on page 7 of the staff memo. The challenge and the various documents submitted are found at Bates stamp 15 through 871. The response from Mr. West is found at pages 872 to 951. Presenting will be Attorney Jeffrey Mandel on behalf of the challenging parties, and Attorney Michael Curran will be appearing on behalf of Mr. West. Do we have Attorney Curran? We do. Okay. So we will begin then. We'd ask Attorney Mandel as counsel for the challengers to present, and he will have 10 minutes. Attorney Mandel.
Thank you, Madam Chairman. Chair, before we begin, I have 2 points of order, please. First, Mr. West did not verify the response that was filed on his behalf before this commission. As a result, as a matter of law, both it and all affidavits that were provided with it should be stricken. Ms. Tidball did sign and verify the response. That's at page 948 of the commission materials. But there is no verified response from Mr. West. The commission's rules on the response to a verified complaint challenging nominations papers are clear. It says in EL 2.07, subdivision 2, paragraph B, quote, "The response to a challenge to nomination papers shall be filed by the candidate challenged within 3 calendar days of the filing of the challenge and shall be verified. Therefore, it requires both that the actual candidate challenged be the one who files and that it be verified." The use of the word shall is mandatory in both statutes and administrative rules, as held by repeated cases from the Wisconsin Supreme Court. Under current Wisconsin law, a verified pleading is required only if a statute or a rule specifies that it is required. But here, the relevant rule does require it. In the past, Wisconsin law had certain exceptions that said that the party who was pleading under certain circumstances might not actually need to sign the verification. However, those exceptions are no longer Wisconsin law. They were repealed in 1976 by Supreme Court order, as reflected at 67 Wisconsin 2nd, page 622. And even if they were still good law, they would not apply here. First, in a multi-party pleading like this one of several parties could sign a verification for a pleading if and only if, number one, that party was acquainted with all of the relevant facts being verified, and number two, that party was within the county where the attorney resides. Here, Ms. Tidball cannot possibly sign on behalf of Mr. West because she was in Wyoming, as one can see from the verification on page 948 of the materials, not in Sauk County, where Mr. Curran resides, which you can see on page 893 of the materials. The second exception that no longer is law, but also regardless would not apply here, is that an agent or attorney could, under certain circumstances, verify a pleading for a party. But Mr. Curran did not attempt to verify the response. You can see that on page 893 of the commission materials. So whether those circumstances are met here is completely irrelevant. Therefore, we would ask that the commission disregard all of the materials filed on behalf of the respondents in this complaint because they were not proper and in accord with law.
Attorney Mandel, can you repeat the administrative code provision that you began your point of order with, please?
Absolutely. It is EL 2.07, subdivision 2, paragraph B.
Okay. Having heard that point of order, we will allow Mr. Curran to respond. Mr. Curran, do you wish to respond to that point of order?
Yes, Madam Chair. Am I correct then that Attorney Mandel is seeking to have all affidavits submitted on our behalf, all papers struck from the record? Is that correct?
It would appear that that is the point of order that is being argued.
Okay. It's my understanding that the substantial compliance was met here by having the complaint verified by the co-candidate, vice presidential candidate. And I believe that she had the authority to verify the complaints submitted by the parties.
And what do you base that on?
Being a party to the action itself, being one of the named people that the complaint was directed at, and therefore she should have the right to file papers, and she did, and verified the complaint or the response to the complaint accordingly.
Do you wish to make any other argument based on the language of 2.072B?
Madam Chair,
Yes.
when you're ready for discussion, I have some questions.
Absolutely. I just want to make certain that all opportunities are given based upon the unusual posture of a point of order in the beginning. So I'm going to allow Mr. Curran to take a quick look at the administrative code, and he can make any additional arguments, and then we will begin our process of contemplating the point of order. Attorney Curran?
Yes, Madam Chair. In looking at 2.07, Parent 2, Parent B, I believe that when we're dealing with a president and a vice presidential candidates and nominees, that the singular would encompass both of them, and that they are treated as a team when it comes to analysis under this section, and that Ms. Tidball or Mr. West could verify a complaint on behalf of the other.
Okay.
That's the way the nomination papers were submitted, and I believe it's appropriate. That's the complaints against them were partnered up, and I believe that the singular there does reflect the plural.
All right. Thank you. Commissioner Knudsen.
When I first read this complaint and the response, I took note of at the top of the response, it said respondents, plural possessive respondents, something like combined complaint or consolidated complaint. And I gave that some thought. I mean, I guess I'd like to hear from our staff attorney if there's any precedent for us, not accepting a response in this kind of a situation where it was consolidated. One of the candidates signed, the attorney, the other has signed. Is there any kind of precedent for us not accepting that response in that kind of a situation?
Yeah, that's a good question, Commissioner. I'm not aware of any precedent. It is interesting that, we generally don't get challenges when you have joint nomination papers, right? So both candidates appear, they kind of run as the ticket, right? President and vice president. So that does present, a little bit of a unique, scenario there. It's usually not an issue that comes up because it's always the singular candidate that is responding, to those verified complaints with a verified response in most instances. So to think of, has it ever happened in the last, 20 or 30 years? It's possible, but I cannot think of any. I'm not aware of any cases in which that has occurred.
Okay.
Commissioner Kendall, you have a question?
Yes, I think after hearing what Nate says and so forth and hearing the arguments, I'd like to make a motion that we continue with the hearing as planned and disregard the point of order that the gentleman for the challenger has.
I second the motion.
Is there a discussion from any of the other commissioners on that? All right, then I will call the vote. The motion is to deny the point of order and proceed forward with the challenge. Commissioner Bostelman?
Aye.
Commissioner Glancy?
Aye.
Commissioner Knudsen?
Aye.
Commissioner Spindell?
Aye.
Commissioner Thompson?
Aye.
I vote aye. The point of order is denied. You had a second point of order, Attorney Mandel?
I do, Madam Chair. Thank you very much. This one I'm stating primarily for the record. I understand that the staff has already discussed this with the administrator and with yourself. But it is our position. We did submit a reply brief within 3 calendar days after the response was submitted. It came with a supplemental affidavit. We do believe those things should be part of the record. The rules of this commission neither require nor prohibit reply briefs, but properly read, they weigh in favor of accepting such briefs. Section 2.07, subdivision 4 of the Wisconsin Administrative Code, EL, says that the commission, quote, shall examine any evidence offered by the parties when reviewing a complaint challenging the sufficiency of the nomination papers of a candidate. It's also the case that general principles of Wisconsin law weigh in favor of accepting such a reply brief. Under general principles of Wisconsin law and Anglo-American law, the party bearing the burden of proof gets the first and the last word. I can cite you Seventh Circuit case, Wisconsin Supreme Court cases, treatises. This is just a general principle of law. It is black letter law that applies any place there is not an express exception. This structure aligns with fundamental principles of due process, which do apply to Wisconsin administrative hearings like this one, according to the Wisconsin Supreme Court in the Union State Bank case at 142, Wisconsin 2nd, page 126. The real concern of due process is about fundamental fairness, as the U.S. Supreme Court and the Wisconsin Supreme Court have held. We did not in any way attempt to prejudice the other side by filing our reply brief, but we did think that we are entitled, where there is time before the commission hearing, as there was here, to have the last word. We think that brief should be part of the record in case there is litigation that goes forward. As I said, I understand that the staff, the administrator, and yourself have conferred upon this, and we just want this objection and this point made for the record. I don't necessarily expect that there will be a reversal of the decision that was communicated to me earlier.
Attorney Judnick, do you want to explain the rationale here?
Sure. It's not real complicated. I think the basis for the decision, when the reply came in, is that these are kind of the standard procedures of the commission. The commission has never allowed a reply brief in these challenges before. It's not something that is specifically prescribed in the administrative code section that talks about it. It says there's a complaint, there's a response, and then the commission makes the decision with or without hearing. So based on the past practice, based on what the administrative code says, that was the basis for why those replies were not accepted, because they were not part of the usual practice. So I understand Attorney Mandel's arguments. However, we're not going to deviate from the normal practice and what our commission rules state. So that is why it was that's why it was determined that way.
Okay.
When the replies were sent, I did send a note to the commission saying that they were filed, but we did not provide any of that information, not as to prejudice any of the commissioners to see a reply that's not currently in the record.
Thank you. Commissioner Knudsen?
Madam Chair, if we had been having this meeting in person and the complainant and the respondent were both there in person, and if they had brought additional written materials and handed them out to them, would we not have accepted them and read them during the course of the hearing? I pose the question to you, but you may actually want to defer it to staff, I guess. But wouldn't it be allowable, acceptable, and has happened in the past that additional written materials can be brought in during the hearing, or am I mistaken? Is our past practice that we rule on the record as it was created with only oral arguments? That's my question.
I will speak as to my own recollection that, as opposed to other matters before the commission, I am not aware of us accepting additional affidavits or evidence of that type during a nomination ballot challenge, as opposed to other matters before the commission. And one of the other rationales that I think is important here is the ability to properly review and prepare for today's hearing, which is challenged dramatically when we have 1,600 pages and such an extraordinarily tight time frame to do it. Are you making a motion to admit those? And
I wasn't really. I was just trying to understand if we had historical precedent for doing that. If part of what was different here is that we're on Zoom and not in person. If they had brought them with and asked to distribute them, would the complainant have been told no? That's my question, I guess, for Nate. Are you telling me that's never happened before, that they brought additional written materials on the day of the hearing?
I don't believe the commission has accepted that in the past, or the GAB accepted that in the past. Information that we generally distribute to the challenges that occur, the larger challenges that occur generally during the June meeting. There's specific information, because of the tight time frames. Here there was a little bit more time, but not a large amount of time, that you get your shot with the complaint, you get your shot at the response, and then you can discuss whatever's in the record, at the hearing, and then the commission can decide. In that case, you have a June 1 filing deadline and a June 10 certification deadline in most cases. So you're, scrambling quite a bit even to get information. You throw an extra reply in there of how many additional pages and other affidavits and other evidence. It gets to the point where, it's difficult to manage and difficult for the commission to consume and figure out, what's going on. So I think that's historically why, it's cut off. That's why the rule is written that way. You get the one shot on the complaint, one shot on the response, and then the commission hears the matter. So I don't believe that just has not, it's not been the past practice.
Okay.
Bill?
I just have a question for Nate. Actually, what the paragraph, was it 2.07, 2.4 actually says, it says the filing officer shall examine any evidence offered by the parties which review the complaint challenging the sufficiency of the nomination papers and so forth. Wasn't that actually done? Didn't Megan and the staff examine the evidence? And did we meet the requirement of that paragraph by the staff examining? It doesn't say the commission has to examine.
As far as the original complaint and the response?
No, I'm just talking about the final one. It says the filing officer shall examine any evidence offered by the parties when reviewing a complaint. And so you're reviewing everything, and this is a document, a third document. Obviously, you've all reviewed it. So it doesn't say the commission has to do that. That's just a question. Maybe there isn't a good answer to that.
I think that that statutory, that administrative code section refers to the complaint and the response. It doesn't contemplate the reply.
Right. Mm-hmm. Okay.
And as a matter of fact, I would also add, if I may, that we were actually very careful not to examine any additional material after the deadline, as not to bias any of the decisions that were made.
Okay,
that's correct. I have not looked at the reply, so I don't even know what is actually in there. As a matter of course, it just it didn't seem like it was an appropriate filing at the time.
Yes, Commissioner Knudsen.
Well, my concern here is really just that we try to stick to our precedent. There's been plenty of chance for us to have been challenged in court over our past practices and administrative rules in the past, but I don't think we have been challenged on that. My concern is if we deviate from that now, do we open ourselves up that, other complainants during this hearing or future hearings or maybe even past hearings go to court and say, hey, I didn't get a fair shake because you're doing things differently now. So my motion would be that we deny the point of order and not accept the reply.
There's a motion on the floor. Is there a second?
I'll second.
Commissioner Spindell seconds. Is there any further discussion? I will call the vote. Commissioner Bostelman?
Aye.
Commissioner Glancy?
Aye.
Commissioner Knudsen?
Aye.
Commissioner Spindell?
Aye.
Commissioner Thompson?
Aye.
I vote aye. The vote is 6-0. The point of order is denied. We will now proceed. Are there any other points of order, Attorney Mandel?
Not respecting this this complaint, Madam Chair.
Okay. Then Administrator Wolf will begin the time, and you have 10 minutes to present to the commission. Go ahead.
Thank you very much. May it please the commission. The nomination papers submitted on behalf of Mr. West and Ms. Tidball were untimely. They were filed after 5 p.m., as the staff recommendation reflects. Statute 8.20, subdivision 8, section AM, says that nomination papers must be filed not later than 5 p.m. And Wisconsin Administrative Code EL 2.05, subdivision 2 specifies, quote, to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline. The papers are not transferred to the physical possession of the filing officer merely when they enter the building in which the commission's offices are held. The deadline for filing nomination papers must be strictly observed. The Wisconsin Supreme Court has so held over and over and over. I think most directly as it respects this discussion in the Stearns case, STEARNS, at 257 Wisconsin Reporter 445. The evidence shows that the filing was not submitted by the 5 p.m. deadline. By her own admission, Attorney Ruland was in her car at 4:59 p.m. That's in paragraph 6 of her affidavit on page 928 of the commission materials. Ms. Ruland exited her car a couple of seconds after 5 o'clock. You can see that in Exhibit A to the Remacher affidavit at 3 minutes and 4 seconds in the video. It took her, as the staff found, between 14 and 20 seconds to reach the building door. You can see that in Exhibit A to the Remacher affidavit at around the 3 minute and 18 to 3 minute 22 second mark. Ms. Ruland's colleague, who held the bulk of the nomination papers, followed her about 8 or 9 seconds later. You can see this too in the video that is Exhibit A to the Remacher affidavit. This means the nomination papers were not in the building by 5 p.m. They were still on the sidewalk outside. The staff memo says that the staff believes that some of the papers first got to the building door at about 5 o'clock and 14 seconds. That's on page 13 of the staff memo. And this fully accords with the video that is Exhibit A to the Remacher affidavit. The staff notes that as well on page 13. Ms. Ruland's affidavit states that she believes that she was in the commission office before 5 p.m., but that is irrelevant. It is not supported by the evidence. It's in paragraph 7 of her affidavit, by the way, on page 929 of the commission materials. And as Wisconsin courts have held, quote, subjective opinion is not relevant, end quote, on a question of objective fact. Time is an objective fact. When the statute says 5 p.m., it means 5 o'clock p.m. Arriving before 5 o'clock, 5:01 is not sufficient. 5 p.m. occurs when the minute hand moves from 4:59 to 5 o'clock. This deadline has been established in case law for more than 70 years. The Elections Commission itself recognizes the strictness of the deadline. It's in the staff memo. On April 10th of this year, this commission discussed the importance of strict adherence to these deadlines. I would point the commission to the timestamp of 31 minutes and 4 seconds to 37 minutes and 23 seconds in the video of that public meeting, where the commissioners discuss at length. And I believe that Commissioner Knudsen and Commissioner Spindell in particular talked about their own personal knowledge and experience of people who are very, very close to the deadline but just miss it, having their papers turned away. The statutes that regulate nomination papers are mandatory, not directory. This commission held that earlier this year in the Jim Sullivan case, case number EL 20-05, decision and order issued on January 21st. And at the February 27th meeting of this commission this year, the commission passed a motion saying, quote, the substantial compliance language in Administrative Code EL 2.05 does not apply to procedural requirements for circulating and filing nomination papers and other election petitions. Procedural requirements involve acts done to the documents and include the time and place of filing, end quote. That is on page, I believe it's page 31 of the commission materials packet for that meeting. Sorry, it's on page 30, numbered page 30 of the materials for that meeting, which was only a few months ago. Even if any time of filing before 5:01 p.m. were timely, and it's not, the nomination papers at issue here were late. Ms. Ruland entered the building no earlier than 14 seconds after 5 o'clock. We've discussed that being in the video and the staff memo. Her colleague followed 8 or 9 seconds later with the bulk of the papers. That left them no more than 36 seconds to walk the length of the first floor, to wait for the elevator, to ride to the third floor, to wait for the doors to open, to walk to the main desk of the commission, and to transfer the papers to the filing officer. That cannot happen in 37 seconds. The staff memo reaches that conclusion on page 15. The video from Matt Smith at WISN 12 News shows that 27 seconds passed between Ms. Ruland's colleague entering the building and the elevator doors closing on the first floor before the elevator even began to rise. The papers were in the elevator and not in the filing clerk's possession at 5:01. In addition, as the staff memo notes, once the papers entered the commission office, Ms. Ruland and her colleagues spent several minutes organizing and numbering the pages before transferring them into the physical possession of the filing officer. The papers were late. Under Wisconsin law, they cannot be allowed. The respondent's approach here tries to eliminate this bright line deadline and force this commission to engage in making unnecessary, involved, and potentially arbitrary factual and equitable determinations. That is a very bad idea. It invites litigation. It creates confusion where none now exists. The respondents attempt to shift the blame for their late filing. They claim that because the doors were locked, it's not their fault. But Ms. Ruland admits that she knew, and she had spoken with the staff earlier in the day. She knew the doors would be locked and she would need to arrange for access. The respondents claim that an overly aggressive media and a Democratic operative caused delay. This is not true. The Remacher affidavit, Exhibit A, the video shows there was no interference. Mr. Smith's news video shows that no one obstructed Ms. Ruland or her colleague. And I would note that this is mere rhetoric in the response. If you look carefully, commissioners, at Ms. Ruland's affidavit, she does not say she was obstructed. She simply says there were other people outside the building. Ultimately, the respondents have only themselves to blame for the lateness of their filing. Every signature on the papers, more than 2,000, was collected on August 3rd and 4th, the last 2 days of the 35-day window. It is no surprise that there was chaos at the end in trying to get them filed. The staff itself cannot extend the filing deadline. We know that. There is no argument that they are ratified as timely simply because the commission staff did not force Ms. Ruland and her colleague to keep the nomination papers, but took possession of them. And the constitutional arguments raised by respondents have no substance whatsoever, as addressed by the staff memo. That's not even the only reason the nomination papers should be rejected. There are improper circulator certifications that when you take care of those, that reduces the respondent's signature count well below 2,000. Several circulators falsely certified. As the commission knows, every circulator must certify that they personally know that each elector, quote, signed the paper with full knowledge of its contents. That is in Wisconsin statute section 815, subdivision 4A, and it is incorporated to this process for independent presidential candidates by Wisconsin statute 8.20, subdivision 3. More than 100 electors signed only because the circulator affirmatively misrepresented the purpose or meaning of the nomination papers. That's in paragraph 22 of Mr. Remacher's affidavit on page 742. If the commission would like, I'm happy during question and answer time to walk through each of those 12 circulators who falsely represented and what affidavits we presented in the 45.5 hours that we had from the time we got those papers from the commission to our deadline. We got 24 affidavits from individuals who swear that they were lied to in different ways and in different circumstances that make those certifications false. If those certifications are false, if the circulators falsely attested, not only those signatures, but all signatures on pages certified by those circulators must be struck.
Thank you. Thank you, Attorney Mendel. Attorney Curran, you will have 10 minutes to provide us with your argument. Go ahead.
Yes, Chair. If before my time starts, if I could make a point of order, please.
You may.
Yes, I would like to dismiss the complaint against the campaign with regard to timeliness as not having jurisdiction. And I'll develop that argument if you so desire. But the complaint was based under 5.06 and 5.06 parent 1. And 5.06 parent 1 describes the situation where a complainant has a problem with the actions of a election official. And that's exactly what is going on here. And therefore, the person that this should have been filed against is not the campaign itself, but against the filing officer who took the papers. What we do know is that a filing officer accepted the filing. I believe we know that a filing officer has no authority to accept untimely filings. No steps were taken by the filing officer himself to correct any perceived mistakes by the filing officer. No evidence that the filing officer believes he made a mistake in accepting the filing is in evidence. There's no clear and convincing evidence that exists that the filing was itself untimely, in that there's no timestamp, there's no official timekeeping mechanism, there's no rejection.
This is not a point of order. This is your response to the challenge, sir.
Well, it's before I get to the response, this is to try to have that the timeliness challenges were not supposed to be against the candidates themselves. They were supposed to be against the filing officer, and therefore the jurisdiction doesn't exist.
Hold that for a moment. Commissioner Knudsen, you had a question on this.
Well, this is another area I thought about some, and I discussed briefly with Administrator Wolf the other day. In the staff memo, this agenda item has staff memo starting on page 1 through page 33, deals with the complaints filed, the 5.06 complaints. But then page 34 deals with the decision of the commission as to whether the filing was timely and sufficient, enough signatures and so on. I don't think I'm misstating. And what I said to Administrator Wolf, or what I was kind of curious about, is it occurred to me that maybe we should have been voting on part 34 first, and then an aggrieved party as to the outcome of that decision would have had a chance to file a complaint against us in regard to our decision. Because really, we haven't made a decision yet for them to complain about by one way of looking at this. I hope I'm being clear, but if you understand what's going on is we have two different decisions to make here today. Had there been no complaint, it would still be our role as the commission to make a determination in regard to each of the candidates who filed a declaration of candidacy. Did they submit enough nomination papers on time, in the right place and manner, in order to gain ballot access? That's our role. We do it every time with every candidate that filed a declaration of candidacy. And if any member of the public or one of the candidates doesn't like a decision that we made, they can file a complaint. Now, maybe I'm confused or misstating that, but I think that's what the attorney's getting at here is we may have this somewhat backwards. Nate, can you, or can any of you see what I'm getting at there?
I think under 8.30 sub 1, the commission has the authority to determine whether candidates have met all of the qualifications, and they have the ability to determine whether they should appear on the ballot or not. So whichever order those go in, I believe, that's ultimately the commission's decision here. It's not the commission staff's decision. Commission staff makes recommendations, but ultimately the commission has to decide, whether those requirements have been met or not. So I understand, the potential confusion there, but I don't really think it is. I think the decision is up to the commission, and they have the ability to, accept those challenges, to those papers because they were filed, and there's a belief that they were filed untimely, and the parties have the ability to offer evidence to support that claim. But the commission also has the independent authority, I believe, under 8.30 to make that determination regardless of the challenge. So I believe, it's up to, I think, the commission how they want to handle that, but I don't think there's anything necessarily improper with the order that these are being addressed in.
Commissioner Thompson.
I think it's absolutely within our jurisdiction to decide this question. That's what we're here to do. We're here today to decide what candidates go on the ballot. And so I would move that the point of order be rejected and get on to the merits and get on to deciding who's going to be on the ballot.
There's a motion on the floor. Is there a second?
I'll second.
Commissioner Knudsen seconds. Is there further discussion on the procedural posture of hearing the matters at hand? All right. I will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
I vote aye. Point of order is rejected. Attorney Kern, is there any other point of order?
I don't think it will. I don't know that it needs to be reheard, but 5.06 Parent 1 contemplates proceedings taking place under Chapter 227, and I would say that this doesn't meet those standards. Other than that, I don't have anything else to add to the point of order.
Okay. You may begin your time to argue.
All right, thank you. Good afternoon, Madam Chair, Elections Commission, staff, and opposing counsel. My name is Mike Kern. I represent the Kanye 2020 campaign, and this is I guess it's the first now of the two cases that we're here for. As I made in the point of order, I think what this is in large part is a challenge to the sufficiency of the timeliness, and it's really not clear that that can be made by challenging the submitters themselves. The facial sufficiency of papers submitted by a challenger certainly is within the realm of a challenger being suited to defend. But once papers are accepted, and in order to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline. What is a filing officer supposed to do if he concludes that the nominator papers are not timely filed? They are supposed to reject the filing. This is what occurred in both of the similar cases cited by both parties in this case, namely the state versus the Conlon versus Zimmerman and the Stearns versus Zimmerman cases. In both of those cases, a filing officer deemed the filings untimely and refused to accept them, and therefore the Zimmerman is the party that the aggrieved party had to pursue relief against. A successful challenge against the sufficiency of the timing of a filing then therefore necessarily requires direct information from the filing officer. We don't have that here. What we have is hearsay. We have no official evidence or statements from anybody related to the filing officer. All we have is hearsay within hearsay statements, and also the staff recommendation that it brought in additional information not in the record, and that's simply insufficient to meet a clear and convincing standard. We know that the filing officer accepted the papers. We know neither the filing officer nor any commission staff took any steps to challenge the sufficiency of the filing. We know no one challenged the filing officer directly as required by 5.06. There is some skirting of this, I believe, by the staff, indicating that they knew that it would be challenged in an abundance of caution. However, that's simply an inappropriate reason to accept filing papers. Had there been no challenge, there would be no question as to the timeliness, because it seems that it should have been something that was fixed by the department itself, and no steps were taken by the commission itself. Now I'll leave those arguments. They were already made in my point of order, and get to the more esoteric arguments about what it means to be no later than. But when we're talking about time periods, no later than includes the time frame in the reference that were used. For example, no later than Tuesday does not mean prior to Tuesday. No later than Tuesday means all of Tuesday. And therefore, no later than 11:59 would mean all of the minute of 11:59, at least when it comes to drafting, filing of documents. And to make 5 p.m. quote unquote late, the proper language would be before 5 p.m. or prior to 5 p.m. or not later than 4:59 p.m. But no later than 5 p.m. does include the full minute. At the top of page 13 of the staff memo, and I'm sorry I did not see the part about referring to the correct page on this, but it is the staff memo, and I assume everybody has that handy. Staff has concluded that the time of 5 o'clock and 14 seconds cited by Attorney Rulin is the time she walked into the building. That conclusion does have secondary support, but it actually misstates what Attorney Rulin swore to. It is in paragraph 14 of her affidavit, and she says in part, when the filing officer arrived at the main desk of the commission, he stated that the petitions were filed at 5 o'clock and 14 seconds, and he would need to confer with legal counsel about the timing of them. In the next paragraph, Attorney Rulin confirmed that all of the documents were accepted and the receipt to her did not have any timestamp. And as at the top of that same page, the staff again cites 5 o'clock and 14 seconds as the time of filing. We simply don't have that in a clear and convincing evidence to that conclusion. And in fact, that he refers to the response using that time throughout its response, but in the response, the first time it gets mentioned is that even if true, and therefore there's no concession by the campaign that the papers were actually filed at 5 o'clock and 14 seconds. Third paragraph of the staff memo, it is correctly stated that the candidate has the responsibility to assure that papers are in compliance with the statutory and legal requirements of Election Code 2.051. However, in the absence of official timekeeping mechanism, and in the absence of the denial of the papers themselves, and in the absence of the filing officer who took the papers taking any subsequent steps to correct any perceived error in accepting the papers, and in the absence of the filing officer's assertion to the contrary at the timeliness of the filing, there's simply no way to prove that the papers were not timely filed when they were accepted by the filing officer himself. And surely with all of the challenges requiring clear and convincing evidence to the contrary, the acceptance of the papers should trump all of that conclusively. At the bottom of page 13 of the staff memo, in its third argument, they conclude that the paperwork was not present in the commission's office before 5 p.m. And that's exactly my point I made previously, that before 5 p.m. is a clearly, the language is clear what that means. And had the language been before 5 p.m., then the campaign would not be making any argument that 5 o'clock and 14 seconds would be within the prescribed requirements of filing. Within the same paragraph, staff claims to being in the office where the filing is required within the required time period is sufficient to meet the deadline. We agree, the campaign agrees, because it would make no sense that one could enter at 4:59 and be stopped from filing the papers because others were in front of them filing papers themselves. And because we know, or at least we believe, that Attorney Rulin stated that she was there at 4:57, that goes to the strength of the argument that she could have been in the office before 5 o'clock had the doors not been locked. Page 14 of the staff memo, various arguments to refute the campaign's arguments are made, but had the filing officer deemed the campaign's filing untimely, delays caused by factors outside of the commission's control, such as stoplights, that would have been the campaign would have to seek relief in a different manner in a different way. And likewise, if the delay could have been mitigated by the commission, such as the locking of the door, just because we had notice, or just because Attorney Rulon apparently had notice of that, that doesn't fix the constitutional problems. And the case for that would be Richmond Newspapers versus Virginia, 448 U.S. 555, 1980. At the top of page 15 of the staff memo, the fourth argument made is that the nomination papers were not in the possession of the filing officer by 501. That's contradicted by the hearsay that we have. I agree we don't know conclusively. That's kind of the whole point of the argument, but I simply don't believe that's a correct conclusion based on what is stated within the affidavit, and that's the only thing that we have that is clear, that is presented as to that, who had possession of them. In the middle of page 15 of the staff memo, a fifth argument is made that acceptance of the nomination papers after the filing deadline does not ratify the filing. It says as timing, it means as timely, but this is circular because the campaign does not concede that sufficient evidence actually exists that the papers were accepted after the filing deadline. Again, it comes back to the point they were accepted and they cannot be accepted after the filing deadline. And without there being any challenge against the filing officer himself, the only fair, just presumption is that accepted papers are deemed timely by the filing officer and therefore can only be challenged with clear and convincing evidence that the filing officer erred and by taking an action against the filing officer directly, as I stated before. I've got some quick not later than examples that are in the statutes. One is 138.14, parent 14, parent D3, where it talks about a payday loan. I agree this is outside of our area of law, but it says no later than 11:59 p.m. on the day that such notification is received. That is correctly drafted language to encompass the full day that follows the day in question. Another one is on 961.385, parent 2. And submit the record to the board no later than 11:59 of the next business day. It was, I'm not saying that the no later than 5 p.m. was supposed to be drafted the way it was, but certainly people became more careful when they analyzed what is going on with regard to a filing that gets near midnight and made the appropriate language. And it makes sense that everything, is that it? Okay.
That is. We're going to begin the part where the commissioners are able to ask questions of the parties. I do have a few questions for Mr. Curran as a preliminary matter. Ms. Rulon's affidavit does not note the fact that she had to number the pages. Is it in fact true that Ms. Rulon was required to number the papers?
I believe that was addressed in the memo itself, and that it looks like it is a requirement of the parties submitting papers, but it also looks like the papers will be accepted whether they're numbered or not. And if I've misstated that, certainly Attorney Judnick can correct me, or Attorney Mandel if he knows, but that's my understanding.
Attorney Curran, my question is, did she have to number the papers before filing them?
I have no knowledge of that.
Okay. A second question I had was paragraph 4 of her affidavit states her earlier instructions received from the commission that she knew that she was going to have to call when she arrived, correct?
I believe that's accurately stated. That's what her affidavit states, correct.
Okay. And it's your contention that even though warned, it was the commission's responsibility to do something other than warn her that she was going to need to call?
It is. It's my contention that that the building should have been held open to the public and that there should have been no hindrances put in the way of any party attempting to file papers.
What if the commission had informed her that the front door was under construction and she was going to need to walk around to the back? Would that have somehow allowed her to file her papers late?
I think it's an interesting question, first of all. I think that had the back door not been obstructed or locked, or had no measures been necessary to enter through the back door, I think that probably does meet constitutional requirements.
What if it was really far away and you couldn't get there in 1 minute from 4:59 p.m.?
I guess my first answer would be it's not the situation before us here. Had it been the situation, I think it would be a strong argument that it was the candidate's responsibility to ensure the papers were timely submitted, and in the absence of obstructions or locked doors, they may not be able to meet their burden. I do have one more question. Are you aware of any case law in the state of Wisconsin that has held that 5 o'clock means between 5 o'clock and 5:00:59 seconds? To answer your question specifically, case law addressing that specific question, I don't have case law. I do have evidence within the statutes and within the electronic filing system that would support the conclusion that it includes the full minute, but not case law.
So you're not aware of any Wisconsin precedent that's held that?
I am not.
Okay. Ms. Rulin's affidavit does say that she believes she was in the office before 5, but not that she was in the office before 5. Why does she not state as a fact that she was in the office before 5?
Yes, I don't know. I'm not sure why Ms. Rulin stated what she stated in the affidavit, but I think one can assume that she did not know what 5 o'clock meant to the filing officer, and therefore trying to conclude what time it is simply outside of her knowledge.
Well, what time does she think she was there?
I'll let the affidavit speak for itself, if I may, Madam Chair.
All right. Finally, as lawyers, we file papers late, they're accepted, but they're filed on the next business day. Why would that not apply in this situation?
Yes, thank you for the question. E-filing requires that papers are filed by 11:59 p.m. and accepted by the clerk the next day in order to be considered filed on the day that they were submitted. And that is a very analogous situation to this. Any papers submitted at 11:59 and 15 seconds would certainly be deemed filed timely by the system itself. And therefore, the idea that by 11:59 would restrict the time period in question, it certainly does include the full minute after the named time. And I think that's the same thing. The same analysis applies to a no later than situation.
I think you misunderstood my question. If you miss it, and let's say under your hypothetical, and I'm not sure I agree with the 11:59 and seconds part, but let's say that you file it at 12 midnight and 1 second, the documents are filed, but they're filed and considered filed on the next business day, correct?
That's correct.
So why aren't untimely papers received by the Elections Commission considered filed the next day?
Yes, and I can say this, Madam Chair, I don't know if they are or aren't. I don't know what the procedures are. I would assume that untimely filings are simply not accepted.
And why would you assume that?
Because if they were improperly accepted, they would have to take steps to correct that acceptance of the papers themselves.
And what do you base that on?
Yes, I base it on the fact that their responsibility is that they follow the law and the filing officer's responsibility is to ensure that with regard to the timeliness of filing, that they ensure that that aspect of the papers is taken care of and is done properly. They are in sole control of that decision as far as I can tell.
Do you have any support for your contention that the filing officer is prohibited from accepting the filing and assigning it filed the next day?
I do have evidence that the filing officer does not have to accept the papers, and that would be the Zimmerman cases that both sides have filed in behalf of different arguments, that the papers were rejected by the clerk or by the filing officer, and therefore the parties aggrieved had to take additional steps to challenge that decision and determination by the filing officer.
I agree that we would have had the authority to reject it at the door. What I'm asking is there any support for the contention that we could not accept them but mark them filed untimely, as in the next day?
I believe that possibility, I believe that may be within the realm of what a filing officer is permitted to do, but they would have to take steps in order to correct such a what I guess I would put in quotes, a mistake, and no steps were taken here.
What steps are required, and point me to some sort of statutory obligation of what the filing officer would have been required to do?
I think that may go back to 5.06, and it would be that an action of the official or a failure of the official to act with respect concerning nominations. I think you would have to challenge it under that. There may be other ways that the staff can take steps to do this, but if that is the proper place where it goes, parent 3 of 5.06 states that the ability to fix any problem has to be done within 10 days. And I guess I would say that the commission is better suited to know if the situation has arisen in the past than I am. And maybe Attorney Judnick could answer the question whether or not they've taken steps to correct a perceived mistake on behalf of the commission.
Why do you say perceived mistake? Are you saying that accepting a filing and marking it filed the next day is a mistake?
And if I can be clear on what you're saying, Madam Chair, when you say, is there evidence that this was filed and marked on the next day, or is this a hypothetical? I'm not aware that these papers were actually marked and as filed on the following day.
Well, what I'm asking is, even if received late, people receive things all the time, right? We can file things late all the time. They are received. They're even filed with the court, by way of example. But the date by which they are considered filed is determined by the receiving entity, clerk of court, or in this case, the Elections Commission.
I agree, and I would state that the only evidence that we have that these papers were filed is that they were filed timely because the election official, the election officer accepted them, with no indication that he deemed them untimely or filed the following day.
Thank you, Attorney Curran. Commissioner Knudsen, I believe you wanted to go next.
Thank you. Attorney Curran, Administrative Code EL 2.05 sub 2 requires that the nomination papers be in the physical possession of the I don't have it in front of me, but of the filing officer. And yet we're talking a lot about what went on at the door of the building. Does the affidavit claim, or is there somewhere in evidence that the candidate or the candidate's agent somehow transferred physical possession at the door?
I don't know. I don't know if there's any evidence either way with regard to that question.
Because my understanding in reading all the papers in the staff memo is that the phone call at 4:57 actually went directly to someone who was standing right near the door. And so there's video of them going back to their car and waiting, but it appears to me that there was somebody waiting by that door to open the door. There was really no delay upon arrival at curbside. There was no delay by that locked door because someone was standing there waiting waiting for them, who then escorted them to the elevator, which was waiting, and escorted them up, at which point the possession was still retained while the candidate's attorney proceeded to add the required page numbers. And at which point, after all of that had taken place, then the candidate's attorney transferred possession to the filing officer. Since EL 2.05 carries the weight of law, the law requires that they actually be in physical possession. It seems to me that there's no evidence that that happened, but in fact, there's evidence to the contrary that transfer of physical possession did not happen before 5 o'clock or 5:01, but happened sometime after that. Do you see this differently, or would that be an accurate understanding of the facts?
I think that the fact that we aren't clear on that point proves the point that the only actions that truly matter with regard to the question of timeliness come down to the actions of the filing officer. And as a sort of an analogy here, when in boxing, when a boxer is knocked down, you don't get 10 seconds to get back up, you get a 10 count. And the person in control of that is the referee. And in this case, I believe that the filing officer serves as the referee, and they determine whether or not the 5 p.m. deadline has been met or not. And here we have a situation where it does not appear that the filing officer deemed this untimely.
So just as a follow-up question as to the 5 o'clock, it seems to me that just common sense and common understanding would be that all the designations of times that start with a 4 are before 5 o'clock, and all of those that start with a 5 are after 5 o'clock. And you could go to infinite number of decimals, and that would be the case. So you've used the example of 11:59 in cases where the statutory requirement is that it happen on a certain day. By the next day would be considered late, on that day was considered timely, and then the statutory construction is that it says not later than 11:59, which is exactly that same situation. Any time that it came in that would be 59.9999 would still be timely. But any time that started with a 12 isn't timely. It's after midnight, and it's actually the next day. To my understanding of it, it's pretty clearly the same thing. 5 o'clock is 5 o'clock. So I understand you're trying to make an argument that 5 o'clock is 5:01, but it just seems to me that, everything that starts with a 4 is before 5 o'clock, and 5 o'clock's the deadline. Maybe I'm just common sense and not a lawyer, but that's the way it seems.
No, Commissioner. To respond to that, I frankly believe it is a drafting error. And I think that it's correctly defined when people are contemplating how to define before midnight. And they say it must be filed no later than 11:59. And I think that there's just a little bit of carelessness there. You can see it in the Zimmerman decisions where they conflate before, they conflate within, and so forth. And that by saying no later than 5, they have added an additional minute, which is how I'm not familiar in law with seconds mattering when it comes to regards of timeliness. It is simply times or minutes and larger components of time. And if, the fractions of a second are simply part of what you would refer to if you're looking at a clock, a digital clock says 11:59, and that is what time you would report to somebody. You wouldn't round up until the clock itself changed.
Attorney Kern, if you set a timer on your phone to go off at 5 o'clock, when would it go off?
It should go off at 5 o'clock sharp, as soon as the clock turned to 5.
5:00:00, so on.
Yes.
So if we had set a timer to go off at 5, would the papers have been in on time or not?
Well, the first response would be that's for the filing officer to determine. But to answer your question directly, I still think that the way the language is set forth, the person would have until 5:01 to file the language, because there it would not be seen or deemed later than 5 o'clock based on the language used and the way other statutes similarly use that language. And again, that's because I think that the time period in question matters, and that's why no later than Tuesday means all of Tuesday.
Question for the staff then, and then I'll be done. Procedurally here, the staff memo introduced things that were sort of testimony by the staff in a couple of places, things that I didn't see in either of the affidavits. And so is it appropriate and proper for us to essentially query or take testimony from the staff as to what happened?
I'm assuming that's for me, Commissioner Knudsen.
Yes.
If the commission desires, that is certainly something they could do. I would offer, however, that the commission staff has no real interest one way or the other. I mean, they're giving their best advice to the commission as to what they believe happened that day. So when there are some statements there that talk about what happened, it's relaying from the individuals exactly what happened. So when we're talking about, a staff member was standing at the glass door receiving the phone call, that comes directly from the person that was standing by the glass door answering the phone. So if you believe that is helpful, it's never really been done before. But if that is helpful for the commission, I don't know if we could handle it right specifically now, because I don't know if those individuals are necessarily available. However, but there is no. So when the filing officer, quote unquote filing officer, it's the staff, but it's really the commission who's making the decision. So what's happening here is the staff who were on the ground are relaying and providing the information to the filing officer here to make that determination. So, some of the statements, absolutely, some of the information that is for the commission to weigh and decide whether they want to accept that information or not. But that is the role, I believe, of the staff when they're making their recommendations. They're providing the commission the information that they know to be true, and the commission is free to then weigh and make those determinations based on what's before them, coming from the staff that were actually on the ground when those papers came in.
Well, let me pose my question, and you can tell me if the question's out of order, or the chair can tell me I'm out of order. Here's my question. I believe the law and the rule says that the papers needed to be in the physical possession of the Elections Commission no later than 5 p.m. My question is, who took physical possession, and when did they take physical possession?
Do you want staff names?
To me, that's the crux of the problem here. And if that person is available to talk with us, I mean, it seems to me like if our job is to find the facts here and find out what's true and right and make a decision that's fair, that's the crux of this. That's what we need to know. Not what time were they on the sidewalk or in the lobby or in the elevator or any of that. Who actually took possession? Like, hey, now they're in the hands of the attorney and now they're not. And that happened at a particular time. When did it happen?
Administrator Wolf, could you perhaps address that?
Sure. One of the things that perhaps I can add to this conversation is just a discussion of our usual practice, not just for this particular deadline, but for all filing deadlines in our office. So staff in our office is instructed on filing deadlines to stand and monitor the doors for candidates that may be entering, challenges that may be entered in our office. So that there is no delay in somebody being able to enter. And that was what staff was directed to do on this particular deadline in accordance with our usual practice. I myself have played that role before, as has Attorney Judnick and others in our office, where we always will have a staff monitoring those deadlines to ensure that it's a smooth process for candidates. Staff is also instructed that they are not the decision makers in these cases. So if there are questions of timeliness, if there are questions of validity, the staff's role is to make recommendations, relay information to the commission as the ultimate decision makers. And that is how we operate in our office always. Staff is instructed that they are not to be making any sort of decision based on timeliness in the office. So that's the role of the commission, to relay the facts and the recommendation to the commission, but ultimately the commission is the one making those determinations.
Okay, who took physical possession? Was it the person that met them down at the door and they walked up, and then once they were up at the desk, there ultimately was a transfer, or were there somebody else sitting at the desk waiting? When did the actual transfer of physical possession take place?
It's my understanding that we had a staff person at the door downstairs who escorted the person up to the front desk, where they met another one of the election specialists who gave the usual information to the candidates about what needed to be done in order to file the nomination papers. And then that election specialist, the two election specialists, took possession of the papers after that had been done. And if you would like their names, we certainly can do that too. I don't know if the chair feels that that's relevant.
Well,
I think we should have I am protective of our staff because, they are not always expecting such things, but I think it's of some importance.
Sure.
So what is the identity of the two staff members?
Sure. Cody Davies, one of our election specialists, is the one that was at the front door and escorted them up to the third floor. And then Riley Williams was also at our other election specialist who was there receiving the papers.
So Commissioner Knudsen, before we decide if we're going to take testimony, I think I'd like to hear from the other commissioners as well, and perhaps return to your question after we've had a chance to discuss that a little further. Would that be agreeable?
Absolutely. I don't want to belabor the point, but I'm still waiting to hear what time was it when that physical transfer happened. You can't have it both ways, staff. You can't say you're not the deciders if it's timely. We are. You just collect the facts and turn it over to us to decide. I'm still waiting for the facts on that. I think I can infer. I've gone up to the third floor before. You can't do it too fast. I don't know what the world record for that trip is. So I can infer that if everyone is agreeing that it was 5 o'clock and 14 seconds at one point, in a best case scenario, we are now talking about whether you can make that trip in something like 46 seconds.
And including the numbering.
I would also if it would be helpful to the commission, I'd be glad to give my account of what the staff relayed to me in terms of their understanding of the time. I'd be glad to do that as well. Or we can work to get those staff on the call potentially to discuss.
And Chairwoman Jacobs, if I may, I was able to while we're having this discussion, touch base with the staff member who met the representatives from the West campaign at the front door to confirm that one, he was there and opened the door so that there was no interference by the locked door. It did not present any sort of a barrier to entry for the candidates' representatives. He states that the transfer of possession took place at either 5:01 or 5:02. And that does not include the time it took for the page numbering. So the papers were placed on the front desk, but were not fully numbered by that point.
So that I understand, they were physically placed on the desk, but they had not yet been numbered.
That is my understanding from the staff recollection of these events.
And then how long did it take to number them?
I don't have a specific answer to that. My guess being that there's multiple hundreds of pages, it would have taken a little bit of time to do that, but we can see if we have an estimate on that.
Okay, so I can clarify, Mr. Rydecki, because I have minutes and seconds in my brain. 5:01 meaning 5 o'clock plus 1 minute to 5 o'clock plus 2 minutes.
Correct.
Okay, thank you. Commissioner Knudsen, if you're completed with your questions, I'm going to move on to Commissioner Thompson, and then I will go to Commissioner Spindell.
You can go, Mr. Spindell.
That's fine. No, go ahead.
Go ahead, Bob. I'll wait.
Commissioner Spindell, it's your floor.
Okay, thank you. This is for Mr. Kern. Would you agree that the pandemic has made life and everything else much harder?
Yes.
And are you aware that the Democratic National Committee is spending over $20 million in legal fees to change state election laws in multiple states, including Wisconsin, to try and make things easier for the voter?
I was not aware of any amount they're spending.
And that it's the Judge Connolly, who has been able to hear this case, will very soon have his order in terms of what needs to be changed in order to make it easier for the person. So getting along that line, it seems that if on that particular day that all this happened, normally, would you, and I think this is probably correct, would you normally assume that the doors to the building would be open at 4:47 or 5 o'clock if we were not in the middle of a pandemic?
I simply don't have the knowledge as to how that building operates. I don't know.
And according to her deposition, she got out of the car, walked to the door. She did not carry the petitions with her because it was her understanding that the door most likely was locked. I went back to her car to make a call to the Election Commission to open the doors. Is that what she stated?
It may be that she made the call when she walked up to the door to get the number, but otherwise I think that's substantially my recollection as well.
Well, if she walked up to the door to get the number, she couldn't make the phone call, could she, until she had the number?
But I think she may, right. I'm assuming that she made the call while at the door, but I don't know for sure.
Okay. I think she indicated she had to go to the door to find the call, and then she went back to the car. But normally, had the door been open, then most likely she would have been able to take the petitions with her assistant and walk through the door if the door was open. Hypothetically.
I think that's a fair assumption that that there would not have been the delay that we're discussing now had the door been open.
Are you familiar with the Conlon case?
No, I am not.
Okay, in that particular case, it was ruled that Conlon versus Zimmerman in 1944, which is 76 years ago, it said if the candidate or someone in his behalf had been present in the office of the Secretary of State to tender the nomination papers not later than 5 o'clock p.m. Central Standard Time, the Secretary of State would have been obliged to accept them. So would that mean that in terms of whether or not the numbers on the pages, whether it's numbered or not, whether it was in physical possession of somebody, is based on that case is really not relevant?
Well, that certainly, I am familiar with the case once you had fully stated it. It was part of the briefs in this matter. And I think that also alluded to that staff also referred to that principle that being in the office does meet the requirements. So.
Now, in this pandemic situation, normally I believe that the staff would not have somebody downstairs and then somebody holding the elevator and then somebody riding up in the elevator to the election office. And when the door of the elevator opens to the election office, if you've ever been there, there is no other door. That is the election door. So do you think that the fact that once the staff person walked into the building, once she walked into the building with the petitions and so forth and so on, and as I understand, she and her assistant got on the elevator with the staff person, just the three of them, would you not consider that could be transfer of documents at that time? And just to go a little bit further, it appears that Mr. Mendel said that going from walking in the door to the elevator was 27 seconds. So if I add 14 to 27 seconds, that means that when the door of the elevator closed approximately, that was 41 seconds. Does that seem to be appropriate?
I agree that it does.
Okay, so it's very possible that looking at it, that once the door closed to the elevator, even more so than just walking in the door of the building, that the transfer of documents took place. And I think we all agree that whether they were numbered or not is completely irrelevant. And basically the fact that somebody is in there in behalf of the candidate it doesn't mean that they have to physically be transferred along that line. So in a situation like this where it appears that everything is being relaxed, and generally, from GAB and Election Commission rules in the past, we have made, and the predecessors to our Election Commission has made everything as easy as possible for the signers, and also easy as possible to have their signatures count. And in a situation like this where the pandemic makes things harder and where everything else there's great efforts in the election process to make everything else different, to spend billions and billions of dollars to try and make the procedure easier for all the voters, then would you agree that we should try and make it a little bit easier, especially when we put roadblocks up, such as a locked door, which prohibited somebody from getting in 14 seconds?
I agree.
Okay, and I've trying to do some research, and on your point about is 5 o'clock, or if somebody wants something in, is 11:59. I did a lot of time trying to find something, and there's no real definitive action. I did notice that in court cases, as you pointed out, that if they want something in by that particular day, it's 11:59. It has to be in by 11:59. And it would, in that situation, 11:59, so to speak, is still 11:59. And I'm just wondering, do you know, 76 years ago, if there were such things as digital watches and digital iPhones that would give the minutes and seconds?
I don't believe there was.
Okay, and would you think that maybe on the grandfather clocks or something along that line, that as the minute hand moves, that it would be 5 o'clock until such time that the hand hit that 1 minute mark after the 5 o'clock, which would then be 5:01. So that would be basically that it would not hit that 5:01 until 4:59, or I'm sorry, it would not hit that 5:01 until it was 5:59 point whatever.
I also agree.
And this case also is 76 years old, which is a long time along that. And I would suspect that the 5 o'clock, would possibly go to 559. But let's take the rounding situation in terms of somebody walking in the building. Generally, when we round off numbers, if something gets to the 30, isn't that normally moved up to the next level? So if it's 5, 4, 5, and 30, it could be considered to be 501, or if it's 524, it could be. It was generally put back to the other area. I mean, that's just simply math in around rounding type errors. So the other question is in a situation like this, and we know it was brought by the Democratic Party. My question is, when do you think the Democratic Party is going to stop trying to suppress the black vote?
I'm going to ask you to pause for a moment. We have lost Commissioner Thompson.
Okay.
And I'm going to ask you to pause for a minute.
It's, on our screen, it's a little bit hard because we don't have Dean on my screen. And we do have and we need the 2 attorneys, Megan, and the 6 commissioners. And I'm wondering if the gentleman who was monitoring this could maybe make sure that all of us are on the same screen. Are you seeing the same thing I am?
Bob, you need to set your settings under video to only see the people who have video. If you go down...
Yeah, but there's more than 6. I can only have 9 on mine.
That's a setting that you control, not the moderator.
Okay.
I've instructed Commissioner Thompson to log back in.
Okay. So we're all set?
Nope, he's not in yet.
Okay. Oh, he's not in yet. Okay.
Jacob, can you please go to participants and invite Commissioner Thompson?
Yes, I had just sent an invite a moment ago.
Did you send it to his work email instead of his state one?
I did not. I can send one to his work email right now. I'll just need that provided. I have a Hotmail email that I will send it to.
I'll send it.
Bob, is your screen showing non-video participants?
Well, now it is.
Like
Sherry,
for example,
Sherry is showing up. Let me take a look at the next screen.
Go in the upper right.
I have you on there and Megan now, and on the other one, who do we pick up?
Go in the upper right corner, for example, of Sherry's.
Yeah.
And then there's a little blue box, ... When you do those settings, it'll give you the choice to just not show them. And then more video participants. And at least move them off your screen. Some of the staff members that are just on audio listening.
Just back on. All right.
Okay. Well, I don't want to try and I better not try and screw it up. Otherwise we may have another.
All right.
Wait.
We are back on the record. Commissioner Thompson has reappeared. Commissioner Spindell, you can continue where you were.
Is it your understanding that the Democratic Party, the media reports say that they do not wish to have Mr. West on the ballot because they're afraid that blacks may vote for him as opposed to Mr. Biden?
I would assume that there are different reasons, but I believe that is likely one of them.
Yeah, I think that's actually a media report. And then that sort of brings me to the point, in terms of the Wisconsin Democrats, which is the people that are bringing this challenge. My question is, when are they going to stop suppressing the black vote? We had the problem in Milwaukee with 180 units being brought down to 5, which definitely affected the black vote. Here, they wish to take away from the black population an opportunity to take a black presidential candidate off the ballot and have a choice in terms of who they want to vote for. And we're, the same thing with the Green Party, where we have a black activist who's running for vice president that they want to get off. And, what's next in terms of trying to suppress the black choice? I mean, the Republicans had an opportunity to try and to do something with the Libertarians, which they did not, and they welcome them. And we got to recognize, that there's some people that may not want to vote for Trump or want to vote for Biden. So I think this situation is something that I would hope that the Democratic Party will try and take a look at and try, in my opinion, their suppression of the black vote. And that's all the questions I have at this point.
Okay, Commissioner Thompson.
Oh, no.
There
we go.
I was interested, this is for Mr. Kern before I get to Mr. Mendel, but Mr. Kern, you had said that if someone had been missing red lights or left late and got stuck at a train stop or something, the candidate would have another remedy. What would that remedy be?
I think it would be a petition to court, perhaps a seeking a writ of cert for extraordinary circumstances causing the inability to meet a deadline. And I'm not exactly sure of the mechanism, but it seems to me that there would be a path to try to convince a court that the campaign should otherwise be accepted.
But I mean, generally, you would accept the premise that if it's 5:02, you didn't make the time, right?
I would, yes.
Okay. See, and this I'm going to sort of address this to Mr. Knutsen's question about whether we need the staff on to tell us how late the transfer took place. See, to me, and this is also to Mr. Spindell, I don't think this is a hyper technical kind of question. I think this has to do with discussions that we've had previously on what is the common sense approach to accepting papers to put candidates on the ballot. And there was a consensus that if you're late, you're late. And that's just the way it is. I watched this video several times. It was clear that the two folks in the car sat in the car for probably over 3 minutes when they could have walked in, because we know that there was someone at the door, and when they got to the door opened immediately. There wasn't an issue, and they didn't get out of the car until 5 o'clock. And the way I'm looking at it, it's sort of like, and this is addressed with Mr. Kern, he said that he thinks that there's a drafting error, and the whole scenario got tested up to go to the courts to find out whether there's a drafting error. I mean, I'm looking at this. Why did they sit there for 3 minutes and wait till 5 before they went in? We all know, it's undisputed, that no one made it in the building until after 5. And Mr. Knutsen asked questions about what time. We just don't know how late that is. We know that it's after 5. We just don't know how late after 5. And I just watched it. We're sitting here arguing, setting up, because it's going to the courts to argue whether or not there's a drafting error. Because this, I do not think it has anything to do with, and what I think the big picture for the commission is, are we going to take the common sense approach and say, look, you're late. There isn't a reason to change it. Everyone knew, Bob brought up COVID-19, everyone knew. And here's sort of a question that I have to both Mr. Mendel and Mr. Curran. How many of the signatures that have been gone through were gathered by the campaign on the days before they were turned in after 5 and late? Did anybody do that calculation?
I did not.
Yes, Mr. Commissioner. Every single signature that was submitted was gathered on August 3rd or August 4th, and the deadline was the 4th. There is not a single signature that was submitted to the commission that I am aware of that is dated prior to Monday, August 3rd.
So they got all the signatures in 2 days. They had them. They got there, and then they sat in the car and waited till 5 o'clock to walk in the building. To me, this is a practical question, and I don't have any more questions. But I think what we really have to vote on is: are we going to say for a candidate, if you're late, you're late? And the consensus was, when you're late, you're late. We can get more testimony to find out, Dean, how late they were, but we all know the papers didn't get into the building until after 5. They weren't close to the office, and they weren't close to being transferred. And this is not a question of seconds or this construction. It's after 5, and that is where we have historically taken the position. And anyway, that's all I have. Thank you.
Thank you, Commissioner Thompson. Commissioner Glancy or Bostelman, who would like to speak next? Commissioner Glancy.
I just have, I think, 2 more comments than questions. Is when you talk about the filing officer, the person who accepted the papers shouldn't have done it. We also have them accept papers that we as a commission later on determine are insufficient. It is not, as Megan had pointed out, that person at the counter who's accepting things to make those decisions. So I don't really feel it was an error on their part to accept the papers when they were handed to them. They maybe should have locked the door at 5 o'clock, but the papers were handed to them, and it wasn't their position or in their power to say, I'm just not going to take them. That would have been an entire other lawsuit. So, I really don't agree with that. The second, point I want to make is we determine whether people have ballot status or not. And I have a great deal of empathy for anybody who files nomination papers, because I've been through that. I know how difficult it can be and how challenging it sometimes can be. But they are required to have this many signatures and filed at this time. And we have taken people having ballot status because they were 1 signature short. So if we're going to hold their feet to the fire on the number of signatures, I think we also have to hold their feet to the fire on the time it needs to be filed. So that, I guess, is my only statement.
Thank you, Commissioner Glancy. Commissioner Bostelman.
I'm kind of on the same wave as Commissioner Glancy. When she and I both were filing officers for our counties, so papers needed to come in on time. And I think the thing that I worry about most is setting precedent. If we need to determine whether something is late or not late, and we can't. I think we need to go with the record in previously, and you all can help me with this because I'm newer and I've never gone through this on the commission, but I'm assuming that prior to this, papers had to be received by 5 o'clock. And if it was not 5:01. So we need to determine now what type of precedent are we going to establish going forward. And I think we follow the past. If it's after 5 o'clock, it's considered late. I feel very strongly about that. I have received papers that were late and were not accepted, and I've received papers that were right on the minute before and yet didn't have enough signatures. So I believe that it's a personal responsibility to make sure that when an individual is submitting papers, nomination papers, that they know that they have enough signatures and they know that they are on time. So and if you can, I guess if it has been 5 o'clock in the past, I don't know how you now decide that what was true in the statute before today is different as of today. And there are many legal attorneys on this Zoom meeting, and if you can explain that to me, I'd be happy to hear that.
Thank you, Commissioner Bostelman. Commissioner Knudsen, we do have the staff members available. This is sort of unusual circumstances. Commissioner Thompson has indicated that it's after 5, regardless of how far after. Commissioner Spindell is of the opinion that there's some fluidity there. Given the unique circumstances, if you feel that you wish to have their testimony, they are available. And as chair, I would allow that. I don't know that I think it's necessary. The staff has told us what time they arrived, but if you wish for that, they are available and we can bring them into the meeting.
Well, all I'm looking for is on page 15 of the staff memo at the top of the first paragraph, number 4, paragraph or item number 4. It states, the papers were not in the possession of the commission by 5:01. And all I'm saying is, I don't know if it's appropriate or not in this hearing for us to hear from our staff. This goes back to what I was getting at earlier when I said there's 2 decisions and there's 2 things on the agenda. One starts at page 34 of the memo, and it's for the commission to decide on our own whether there were sufficient signatures timely filed. And then there's our decision on the complaint that was filed, and they cover the same material. I don't really care procedurally. I mean, here we are. But I think the crux of both of those is encompassed in that fact. If we're to take this staff memo as fact, do we need to have somebody read it into the record so that we're ready for on potential appeal that this is what we based it on? And that's basically what I'm saying. It's my desire, but I'm posing it to you guys, to the staff and Nathan as a question. Do we take this as sworn testimony, this staff memo, or do we need to have a staff member come before us and swear to us that they were not in the possession of the commission by 5:01? That's my question, Nate. And I mean, to me, this all kind of hinges on that. That's what it's all about here.
Sure.
And you see where I'm going?
I do.
Can you help me out?
Yeah, I think so. My response to that would be, when these types of cases have gone to court, the staff recommendation memo is always part of the record that goes to the judge under a 227 type administrative review. So it's the complaint, it's the response, any of the exhibits that were part, the staff recommendations, the memo, any of the motions, all that goes is part of the record. So that does go to the judge for them to review, and then they weigh and determine, what was the commission, proper in making their determination based on, what the recommendations were and what the evidence was provided, to them. So, as far as, the statement, the nomination papers were not in the possession of the filing officer by 5:01, that was stated because of the conversations that we had with the staff. The 5 o'clock -14 was not, when they, filed or took possession of it. It was at the door.
Nate, if you'll hold on for a moment, we lost Commissioner Thompson again.
Okay.
I will send an invite to him again. We get Commissioner Thompson? Commissioner Thompson is rebooting, so hopefully he'll be on very shortly. And Commissioner Thompson is back. All right.
Okay, so here's what I'm trying to get at is that statement at the top of page 15, the papers were not in the possession at 5:01. By what means was that determined? Who determined it? On what is that statement based on? What did somebody look at their own watch upstairs? Have we tried to, is there security camera video or some other means within the building for us to know what was going on and at what time? What steps have we taken to verify that that statement is actual, true and factual?
It is based on conversations with Riley, who was the individual that, was at the elevator, when the individuals came off the elevator. That's based on the fact that
I'm going to pause you there. I think the answer to this is both of these gentlemen are available, and in the interest of creating a complete record, my intention would be to bring them in front of the commission to briefly be sworn and enter testimony. The commissioners may ask any questions of them they wish. I'm not going to have, I don't think, the parties specifically question them unless there's some particular reason to do that, because I think it's going to be, this is not really a trial, but I think Commissioner Knutsen's questions of exactly the factual basis, they're available to us. I think if we were live, we would bring them in. So we will bring them in. Administrator Wolf or Mr. Rydecki, is one of you able to bring them into our meeting, please?
Yes, we are. We've added them as panelists, and they will be joining us shortly.
Thank you.
And Madam Chair, forgive me if this is out of order, but can I make a point, please?
Briefly.
Yes. Pursuant to 2.05 of the Election Code, extrinsic evidence is appropriate when challenging the facial sufficiency of a complaint. But we're talking about the timeliness pursuant to parent 2 of that statute. And I just don't know that extrinsic evidence is appropriate under these circumstances. And so to the extent I can object, I will, but I understand that that may not matter.
Well, let me ask you this. Are you conceding that the papers were not in the hands of the filing officer at exactly 5 p.m.?
No, not at all.
Okay. Then who was at the door? Was that Riley?
Cody Davies was the election specialist who was downstairs at the front door, and Riley Willman was the one that was on the 3rd floor waiting to receive upon them getting off the elevator.
And is Cody Davies available to be on video?
Yes, he is.
He is. Okay. We're going to begin with Cody because he was at the front door. Cody, would you please raise your right hand? You solemnly swear or affirm that the testimony you are about to give is the truth and the whole truth and nothing but the truth?
I do.
What is your complete name?
Cody Christopher Davies.
How are you employed?
I'm an elections administration specialist for the Wisconsin Elections Commission.
Thank you, Mr. Davies. You can put your hand down. We are here discussing the filing of the nomination papers of Kanye West, which occurred on, let's see now, August 4th, 2020. You are aware of that?
I am.
And at August 4th, 2020, at approximately 4:55 p.m., where were you?
I was downstairs at the lobby at 212 East Washington waiting for anyone who might try to file nomination papers prior to the 5 o'clock deadline.
And what were your instructions?
My instructions were to watch the front door and make sure anyone who would try to file papers was able to enter the building and to escort them upstairs if they did.
Right. And what did you observe that afternoon at between 4:55 and 5 p.m.?
There were a number of folks outside with cameras. I can't stipulate how many of them were out there. I saw at least 3 folks. 4:55 is when I went downstairs. At 4:57, I was also the individual who took the phone call from the campaign staff indicating that they were approximately 3 minutes away. I remember saying something to the effect of 3 minutes is bad, 2 minutes is better, as it was 4:57 at the time. And as soon as I saw them coming up the stairs, I went to go open the inner door. They had opened the outer door themselves. 14 seconds or so after 5 p.m. is my best recollection as to when that happened. I had been observing the clock icon on the face of my phone. I remember the little red second hand clearly passing 5 p.m. and after 12 to 14 seconds, they reached the stairs in front of the building, and I went to go open the door. I escorted them upstairs.
I'm going to pause you for just
Yes.
a moment, Mr. Davies. Did you inform them at that time that they were 14 seconds over?
I do not recall if it came up at that time. There was a discussion when we got upstairs that I needed to consult with management and with staff counsel, as they had filed effectively after 5 p.m., and I was uncertain at that time of how to best proceed.
Okay. So when you opened the door between 5:12 and 5:14 p.m., 5 o'clock and 12 seconds or 5 o'clock and 14 seconds after 5 p.m., where did you then go? Please trace your route for us.
Of course. So the 2 members from the West campaign and then 2 other folks followed them in the door. I believe they were representatives of the media. We then proceeded to the main elevator in the building here, at which point the 2 representatives from the campaign and myself entered the elevator. The 2 representatives of the media asked if they could come along. I didn't feel as though that was appropriate. It was after hours, and social distancing being what it was, I think we're already a little packed into the elevator. Then we had to scan in, so the access to the third floor is restricted to members of the Wisconsin Elections Commission. So I had to scan my ID badge. The doors closed, and then we went upstairs. After that, as was mentioned earlier, the doors open. You are immediately in the office. At that time, I would say,
I'm going to ask you to pause there for a moment, please.
Of course.
At any time prior to the moment when the doors of the elevator opened into the offices of the Election Commission, had you taken possession of any of the petitions?
I did not. We did not touch the papers until after they had been put on the counter at the front desk.
Okay. Were you present when those papers were placed on the counter of the front desk?
I was.
And to the best of your recollection, at what time were they placed on the counter of the front desk?
I cannot say for certain. I know I did glance at my watch while in the elevator, but I cannot give a specific time as to when that would have been.
Are you able to tell us what time it was when you glanced at your watch in the elevator?
It was about 10 seconds before 5:01. I cannot speak to the accuracy of my watch, however.
Okay. When the documents were placed on the counter, did you have any further interaction with the persons filing them?
It was at that point where I told them I was going to go back to my desk to try to reach management and Nate to discuss how to best proceed, because there was a question of timeliness. One of the representatives at that point informed me that the statute said 5 p.m., not 5:00:00. And I said, okay, and I do need to confirm that with staff counsel. And then I went back to my desk immediately. After that, intermittent, because we were going back and forth trying to, process the papers and get a hold of someone else with legal expertise at that time. So between Riley and myself, we did interact with them for probably the next half an hour intermittently.
Do you have any reason to believe your wristwatch is inaccurate?
Not, outside normal inaccuracy from a wristwatch. It costs $25 on Amazon, so it's not an atomic clock by any sense, but it's fairly accurate, I would say.
Okay. Have you had any problems with it losing time or otherwise being inaccurate?
The greatest inaccuracy I've found so far is that it is set on a 30-day calendar month, so it gets a little problematic around leap years, but other than that, no.
Okay. All right, so those are my basic outlines of the questions for Mr. Davies. If the commissioners have any specific questions on topic, which is as to his knowledge, they may ask them. Commissioner Knudsen, do you have any additional questions for Mr. Davies? Commissioner Thompson.
As I said, it's not for us to determine how late the papers were. We have unequivocal testimony that it got into the building after 5 o'clock. So I have no questions because I don't think it's relevant to any issue.
Commissioner Spindell, as to Mr. Davies' specific factual testimony and limited only to that.
Yes,
do you have any
yes, I will. You indicated that you were in the lobby at 4:55. Were you off the elevator and in the lobby at 4:55?
I was, yes.
Okay. And around 4:57, did you see anybody approach the door to the building and then walk away from the building?
I did not. Just the individuals who were congregated outside of the building prior to me arriving downstairs. Neither of the representatives who ultimately came upstairs with me were down there.
Okay, and then you indicated that you received a call from at 4:57, and who was that from?
It was from someone identifying themselves as a member of the West campaign, saying that they were on their way to drop off the papers.
Now, when they said we're on our way to drop off the papers, did you think that meant they were, I think you indicated 3 minutes away. Did you think they were driving, or did you know that they were outside?
I was not aware they were outside. To my knowledge, it sounded like they were still driving. They had indicated that there were people in front of the building and that there were people on the corners of the sidewalk. So some of the commentary was not the clearest. So yeah, like I said, it sounded as though they were still driving toward the building at that point.
Okay, and then at some time before 5 o'clock or whenever that might be, did you see the car out in front of the staircase, I guess, to the building?
I did not.
Okay, so the first time you saw somebody that resembled this particular group coming in was as they started to walk up the stairs and towards the front door?
Correct.
Okay, when you saw that, did you? How far were you from the door when you saw that? Were you right at the door?
I would say I was about 3 feet from the door. As soon as I saw someone approach the bottom step, I went to go open the inner of the two doors at that time.
Okay, and then they basically didn't have to wait for you to open the door. The door was open and they could walk right in. Is that correct?
The outer door, as soon as they opened that, the inner door was already open and they proceeded immediately in.
So they had to open an outer door, which I guess is like a storm door or something like that, and then there's an inner door. Is that the way that's set up?
Correct. There are two glass doors down there. They're both roughly of the same design with a little antechamber in between them. The outside door, they opened themselves. It was not locked. I opened the inner door at the same time, so they didn't have to wait in either case.
Okay. And on before the pandemic, at previous times such as these, was it the practice of the Election Commission to have somebody downstairs to point people to the elevator so they could get up upstairs?
To my recollection, prior to the pandemic, the building manager would keep the doors unlocked. There would be signage that would indicate where we were, where the filing officer's desk was. The elevator did not used to be restricted access to the third floor either. So no, I do not believe that in previous filing deadlines there was someone downstairs. But
okay, and then you got in the elevator, and I think Mr. Mandel indicated that it took 27 seconds. That they came in about 5:14. They got through the door. 27 seconds to get in the elevator. And when you looked at your watch at 5:50, were the doors to the elevator closed?
They were still closed. We hadn't reached the third floor yet. Okay,
so you were in the process of at 5 o'clock and 50 seconds. You were somehow going up in the elevator. Do you know approximately how much? I've been in several times. I know it's awfully slow elevator. Do you know how long it generally takes to get from the first floor to the third floor in the elevator?
Not offhand. I suppose I've never thought about it.
Yeah, I don't think we did. And then so basically to recoup, it came in about 14 seconds after 5 o'clock. You were in the elevator at 5:50, and as you indicated that when the door opens to the elevator, that in effect is the door to the Election Commission. Is that correct? There's no other door that somebody has to go through?
Correct. You're immediately at the front desk.
Okay. And given the where you were, in terms of when you looked at your watch, do you have any idea approximately what percentage of the ride from the first floor to the third floor that you had taken when you looked at your watch? Was it a third, 2/3, half? Any thought on that?
I can't speak to that. I know there was still some time, and as you've ridden in the elevator yourself, you know that after the elevator reaches the third floor, there is a momentary pause before the doors open. I can't exactly tell you how much of the ride had.
Okay. And have you been in the office at times when, not during this time, but during your career at the Wisconsin Election Commission on filing days?
I have.
Okay. And generally, what takes place? I know in the last one that we had the filing at a different location, but what is the normal procedure at 5 o'clock? If there's a line of people that get in there by 5 o'clock, so to speak, chances are, if there's more than one or two people in line at 5 o'clock, that the people in line other than the first one is not going to be able to transfer their papers to the clerk at the desk. Is that correct?
Honestly, I can't speak to that. In most filing deadlines, in my experience, there has been a member of the front desk staff there processing intake and doing that portion of the process. I would typically be at my desk at that time waiting to be called up to review papers or speak with the candidate. So I cannot speak to normal procedures at 5 p.m.
Okay. Have you ever seen at 5 o'clock on some of these election, the days that the filings are due or the petitions are due, when there's more than one candidate filing at 5 o'clock in the airport?
Commissioner Spindell, I did ask that we limit our questions.
Okay, that's fine.
To Mr.
That's fine.
Whitman.
All right. Well, thank you very much.
Observations of the day of filing.
That's fine. That's fine.
About the general procedure are best directed to Administrator Wolf or Mr. Rydecki.
Okay. Well, thank you very much. Appreciate it.
Okay.
Thank you.
Do any other commissioners have any questions for Mr. Davies? Hearing none, thank you, Mr. Davies. You are released. I'm going to ask Mr. Willman now. Mr. Willman, are you able to unmute?
Yes, I should be unmuted.
Yes, you are. All right, thank you. If you would please raise your right hand. Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your complete name, please?
My full name is Riley Peter Willman.
How are you employed?
I'm an election administration specialist at the Wisconsin Elections Commission.
How long have you had that position?
About 2.5 years.
We are here discussing, you may put your hand down, sir. We are here discussing the events of August 4th with regards to the filing of the Kanye West nominating papers. Were you involved in that process?
Yes, I was in the office on that day.
Can you please describe for us what you saw as to the arrival of those papers?
Yes. So my colleague Cody Davies did go down to the lobby shortly before 5 to watch the front door to see if anyone would come in while it was locked. I was at my desk as we had another candidate who had come to the office around 4:30 who was being processed by another specialist who did need her documents notarized. So at 5 o'clock, I noticed on an agency cell phone that is tied to an alternate number used for the front doors. I noticed that it was 5. Went up to the lobby where then I saw the representatives from the West campaign and Cody Davies were there and then started talking with Cody about the time of the filing.
And when you say they were there, were they already stationed in the lobby? Were they coming off the elevator?
They were in the lobby.
Okay. Where were the papers?
They were still in the hands of the West representatives.
Okay. And what happened to those papers?
They put them on the counter and then started going through and organizing them. They had to number pages. They had to organize them. Both representatives had stacks of their own.
Did they tender them to you for filing at that time?
At that time, they were simply on the counter. They were going through and organizing them. We did not begin the normal check-in process until a couple minutes later after we had been able to reach Nate and some management members to discuss what next to do.
And did you personally speak with Nate or management members?
I did not speak with them, no.
Okay. While they were organizing the papers, had anyone handed them to you?
No, we did not touch those papers until after we had talked to management and council. At
what time, to the best of your recollection, did those papers land on the desk?
To the best of my recollection, it was at 5:01.
Okay. And at what time, to the best of your recollection, were the papers organized and numbered as required?
It would have been several minutes after 5:01. I'm not sure the exact time, but they did take a couple minutes to organize the papers themselves.
Okay. Do any of the commissioners have additional questions as to Mr. Willman's specific factual recollections of the filing of the West papers?
Yeah, I just have one question. When you took a look at your, what did you do? Take a look at your watch, clock? Where did you see the 5:01? What sort of timepiece was that?
That would have been my watch.
Okay. And when you looked at your watch, what had been accomplished by that time?
They were just in the front of our office. So I don't know if they had just stopped off the elevator, but I kind of turned around the corner and noticed that they were in our office.
Okay. And do you know if it was closer to 5:02 or 5 o'clock? You probably don't have an idea on that, do you?
I'm not sure of that, no.
Okay. That's all I have. Thank you.
Any other commissioners have any questions for Mr. Willman? Okay. Thank you, Mr. Willman. Oh, Commissioner Knudsen.
Sorry, I'm slow on the unmute. Riley, my original question before you joined the meeting here was, at what time did the Elections Commission staff take physical possession of the papers?
It would have been several minutes after 5 as they were organizing them. We wanted to check with staff of what to do next. As long as I have worked at the commission, we have not had someone file so close to the 5 p.m. deadline. So I was not aware of how to proceed going forward. So as far as I can speak for myself, I did not touch those papers until several minutes after 5 when we began the normal front desk check-in process.
Okay, thank you.
Just to clarify, following up on Commissioner Knudsen's question, was there a delay between when they were done organizing the papers and your receipt of information from higher ups to accept them?
I was not aware. I was not at the front desk. There was a time period where they were at the front desk where we were still waiting to hear from management. So I was not up there at that time.
Okay. All right. Anyone have any other questions? Okay. Thank you, Mr. Willman. You are excused. All right. All right. Do commissioners have any other questions for, I think we were sort of, well, I guess technically I will ask, do the commissioners have any questions for Mr. Curran or Mr. Mandel at this time?
I just have one for Mr. Mandel.
Okay, go ahead.
Okay. Mr. Mandel, obviously you're familiar with Colin versus Zimmerman. And are you familiar with the fact that the case states if the candidate or someone in his behalf have been present in the office of the Secretary of State to tender the nomination papers not later than 5 o'clock p.m. Central Standard Time, the Secretary of State would have been obliged to accept them?
Commissioner Spindell, I am aware that that the case says that. I would suggest to the commission, however, that that is not a constitutional rule. That is the court's explanation of what the rules and statutes were at the time. And now we have Wisconsin Administrative Code, Chapter EL 2.05, Subdivision 2, which is much clearer. And it says, quote, in order to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline, period. Each of the nomination papers shall be numbered before they are filed, and the numbers shall be assigned sequentially, beginning with the number 1, period. So, I think that respectfully, I would suggest that the Wisconsin Administrative Code, which is the law of the land, trumps the interpretation of the Supreme Court of the rules that were in place at that time.
Mr. Curran, do you have any response on that?
I'm not familiar with what the law was on the books at the time the Supreme Court decision was made, but certainly the Supreme Court decision makes more sense when you take everything in its totality.
Okay, thank you.
All right. Do any other commissioners have any questions for the attorneys? Do any of the commissioners have any questions for Attorney Judnick before we go to discuss whether or not there are motions before the commission? All right. I will now, there are suggested motions, and for those who are watching this hearing remotely, those are suggested motions that are made by the staff, and the commission is allowed to make those motions, make other motions, and the like.
If I may, Madam Chair.
Yes, Commissioner Thompson.
I believe that the applicable motions on this, if I'm right, are at page 28 and 29. Am I correct?
You are. I was just paging through my materials to find those pages. Thank you.
Recommended motions 1 through 8. I would move and make the motion, or make those motions.
Commissioner Thompson moves recommended motions 1 through 8 on pages 28 and 29. I'm going to allow the commissioners to turn to those pages and review them.
We also have a visual if the chair would like us to bring them up on the screen.
I think that would be terrific. There is the summary of the challenges. Okay, and do we have the suggested motions, please, Jacob? All right. And the next slide, please, with the remaining motions. And the next slide, because there's still more. All right. We have a motion to adopt or a motion on the floor. Is there a second from a commissioner?
I'll second.
I'd like to make a friendly amendment.
Well, hold on.
Okay.
Commissioner Glancy has seconded the motion. All right. Commissioner Spindell wishes to seek leave to have a friendly amendment.
Yes, my friendly amendment is that we consider 2, 3, 4, 5, 6, 7, 8, and then come back for the motion on number 1.
Commissioner Thompson, what is your decision?
Unfortunately, I didn't hear his comment.
Okay, I'm sorry. My amendment would be that the commission consider for this motion 2, 3, 4, 5, 6, 7, 8, and then in a separate motion we would come back to number 1 for discussion.
Commissioner Clancy?
I think we need to take number 8 with number 1 if we're going to divide the question, because number 8 refers to submitting the findings, and we won't have done that until we've done number 1.
That's fine.
Look, I don't have a problem breaking it down if Mr. Spindell wants to take 2 votes.
Okay, Commissioner Thompson, it's your motion. Which ones do you want to do first?
My friendly amendment was that we do 2, 3, 4, 5, 6, 7 first.
But you didn't make the motion, so Mr. Thompson sort of gets to decide on that one.
No, I understand. Yeah, amendment.
We'll make that the first motion. Yeah.
Okay, so the motion on the floor is to adopt recommended motions 2, 3, 4, 5, 6, and 7. Commissioner Glancy, do you again second that motion?
Yes.
Okay, is there discussion on those recommended motions? Hearing none, I'll call the vote. Commissioner Bostelman?
Aye.
Commissioner Glancy?
Aye.
Commissioner Christensen?
Aye.
Commissioner Spindell?
Aye.
Commissioner Thompson?
Aye.
Jacobs votes aye. Those are passed unanimously. Commissioner Thompson, are you moving number 1 now?
Number 1 and number 8.
Number 1 and number 8. Commissioner Clancy, are you seconding 1 and 8?
Yes.
Okay, we have motions as to number 1 and number 8. Is there discussion on those motions?
Yes, I'd like to say something if I could.
You may.
Okay. I think this is a very interesting situation. And I think had the pandemic not been around like many things, the people here would have been able to get to the upstairs at the appropriate time. I think there's probably, in terms of whether it should be 5 o'clock or whether it should be 5:00:59 or whatever it is, I think it's pretty clear that in terms of the time frame, that the person was pretty close to the office by 5:00:59. As a matter of fact, the gentleman said that he looked at his watch somewhere on his way up to the office, where the door of the office again is the elevator, and it opened. Whether it's my contention, basically, that the time of possession should be when the person representing the West campaign walked in the door at 5:14. Given that there was some more time involved in that, and somewhere at 5:50, 10 seconds before the magic number, so to speak, they were somewhere in the elevator. We're not quite sure in terms of what time the elevator opened. Did it open at 5:00:59? Did it open at 5:01:001? I think that's a question that is out there. But I think that we need to put Mr. West on the ballot here. I do not think it's right that we go against. Maybe it's not 2,000 signatures, maybe it's 1,800 or whatever. If there's 100 that said they didn't do it, of course we don't really know that. But 2,000 people indicated that Mr. West should be put in the ballot. Mr. West is an African American candidate, and I think we should do all we can to, after the terrible treatment that the black population in Milwaukee received during the April election, that we give them a choice. I don't think it's up to us to say you cannot have a choice in terms of which candidate you would like to vote for. So basically, I think it was close, but I think that it was handled before 5:00:59. And I think all indications, and I spent a lot of time trying to find something definitive on this, but I did see 11, for court records, 11:59. It has to be in by that time. It should have said 4:59, but maybe 76 years ago, they weren't paying attention to the seconds as we are now. So it's my belief that we should reject number one.
Would any other commissioners like to speak? Commissioner Knudsen, you waved your hand.
Well, this is one of the closest call cases that I've seen, but consistency requires me to treat all candidates the same, regardless of their party, regardless of their color or any other characteristic of the candidate. Sometimes I've said our job is to call balls and strikes. This time it feels more like we're a line judge determining if somebody stepped out of bounds or crossed the goal line, and it is a close call. I think the complaint has the burden of reaching clear evidence, clear factual evidence that it wasn't timely, and I think they meet that burden. So to me, while I regret that, it's the case, I do not feel like they filed timely. And so I'll support the motion.
Thank you, Commissioner Knudsen. Commissioner Bostelman.
I go back to what I said before, that I think we need to be careful of whatever type of precedent we set here. And I believe that it was not timely. And I agree that I feel bad that it's not, but I also believe that other candidates were able to get filings in on time. And I think that that's regretful that they didn't get it in on time, but I think we need to stick with, we shouldn't set a new precedent based on how things have been voted for in the past. And it seems to me that I've been told that if they were late, they were late. And I guess I also support the motion.
Thank you, Commissioner Bostelman. Do any other commissioners wish to be heard?
I just have one more comment. I don't think they were late. I think they met the requirements by before 50059, and therefore I do not think they were late. I guess in future times we're going to have a. I don't think the decision has still been made in terms of whether 5 o'clock is 5000000 or 5 o'clock is 5000001. I guess we'll need some sort of time clock up there that's based in a direct line to the tower in London or whatever it is that has a world's time to make sure that we're exactly right. I mean, we are talking a matter of seconds here, and I don't think that the all the information that we have gotten does, even though that the door to the office, which is the elevator door to the office, which is the door to the election commission, that they weren't there by 50059. And so the question in terms of is it 5000000 or is it 50059? Which one is the correct time? I know I used to own a bunch of restaurants, and if somebody showed up at 10 o'clock at night, they could get in. If somebody showed up at 10:0001, the help could have closed the store. So it's my belief that yes, she was on time, and two, that the transfer took place as soon as our staff member met that person in the lobby and went up in the lobby with her, because in the past there has not been anybody in the lobby to do this because of this very unusual situation. Thank you.
Thank you.
That's all I have.
Are there any other commissioners who wish to speak on this?
I call the question.
Commissioner Thompson calls the question. We will take a vote. The motion is recommended motion number 1, that the commission sustains the challenge to all nomination papers submitted by Mr. West and Ms. Tidball because they were not filed timely in accordance with Wisconsin Statute 8.20 sub 8 sub AM. Therefore, their names shall not appear on the 2020 November general election ballot as independent candidates for president and vice president, respectively, in Wisconsin. Commissioner Bostelman, what do you vote?
I vote. Did you hear me? Aye.
Commissioner Bostelman votes aye. Commissioner Glancy?
Aye.
Commissioner Glancy votes aye. Commissioner Knudsen?
Aye.
Commissioner Knudsen votes aye. Commissioner Spindell?
No.
Commissioner Spindell votes no. Commissioner Thompson?
Aye.
Commissioner Thompson votes aye. I vote aye. The motion is carried 5-1. We have been at this for 2.5 hours. Would the commissioners like a brief break before we take the next challenge?
Sure, that'd be nice.
Thompson's waving his hand. Is that a yes, Commissioner Thompson?
That's 5 minutes.
5 minutes. All right. We will take a 5-minute break. And please make it exactly 5 minutes because we got a long way to go.
It's 5:33. Do we want to make it just, 5:40? Make it so we have a definite time?
5:40 at the request of Commissioner Spindell. Please be back.
Okay. Thank you.
And so I thought maybe that's a way to, yeah, I know. All right, do you need anything?
Maybe small water. Yeah. Thank you.
Hey, Reed, you're not muted.
Before we go back on, Jacob, do we have Mr. Santeller?
I was told that we do.
Mr. Sinteller is on by phone. He indicated he was having connectivity issues and not able to appear by Zoom.
Okay, thank you. Commissioner Bostelman, are you back? There we go. 1, 2, 3, 4. There we go. 1, 2.
I believe we have all commissioners and staff that were expected.
Yes, it does appear so. We will reconvene the meeting of the Wisconsin Election Commission. We do have a challenge by Joseph Santeller, who will be appearing by phone. As with the previous format, we will allow Mr. Santeller to present for up to 10 minutes. We will then allow Attorney Curran to present for up to 10 minutes, and then the commission will be able to ask them questions, ask questions of staff counsel, and then entertain any motions. Mr. Santeller, are you on the line?
I am on the line.
All right, you may proceed. You have up to 10 minutes to discuss with the Elections Commission.
Thank you, and good afternoon. I'd like to thank members of the commission as well as commission staff for all of your time in waiting for me to get connected and hearing the complaint today, and for taking the time to review this. So thank you for that. I'd like to start with a similar point of order that was raised by Attorney Mandel by noting that the response to my complaint was not verified by the candidate I challenged. Now, this point is different in my case because I didn't name Vice Presidential candidate Tidball in my complaint. So the only candidate challenged in my complaint is Mr. West. And that candidate did not verify the response. So in my view, the allegations in my complaint stand unrebutted due to the candidate challenged failure to verify his response in accordance with section EL 2.07 sub 2 pair B. So that is an initial point of order I'd like to make.
Okay. Does the commission wish to discuss the point of order, or is there a motion on the point of order?
Does anyone have the page number of the response to this in the 1,600 pages?
Yes, I pulled it.
Madam Chair, if I may, it's Jeff Mandel. The verification is on page 948 of the commission materials.
Thank you, Attorney Mandel. That's very helpful. Okay, Commissioner Knudsen, does that answer your question, or are you looking at it online?
I'm looking at it, or trying to.
And Madam Chair, just in case I misunderstood Commissioner Knudsen's question, the response itself begins on page 872 of the commission materials.
Okay.
As we discussed, it was a joint response, so it responds to both. So the same response that was filed in the Brent matter is the same response for this matter.
Oh, I see. Okay. Okay, that's my only question.
So the point of order was that Mr. Santeller's challenge was directed only to candidate West and not to candidate Tidball, and therefore and therefore it is lacking verification. Is there a motion from any commissioner regarding this point of order?
Mandel. I make a motion that we disregard this point of order and continue on with our hearing.
Okay, there's a motion. Is there a second? Commissioner Knudsen seconds. Is there further
Second the
discussion on this? Are you seconding, Commissioner Knudsen? Yes, okay. Is there any further discussion on this point of order? Hearing none, I'll call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
Chair votes aye. We will continue. Are there any other points of order, Mr. Santeller?
No.
You may proceed with your arguments. Commissioner Administrator Wolf, if you would return the clock to 10 minutes. Go ahead, please.
Thank you. As I note in the first count of my complaint, Wisconsin statute section 8.202B contains a general requirement for most independent candidates for office that their nomination papers merely include a candidate's mailing address. However, the statute sets forth a different requirement for presidential candidates, that they state their residence and post office address. Now, while the parties may disagree on what this actually means in terms of the word residence, it has to mean something more than a mailing address, in my opinion. Otherwise, the legislature would not have parsed this out and made it a requirement separate from the mailing address requirement that applies to all other candidates. So in this case, even accepting the candidate's version of events as true, he only provided the mailing address of his campaign. While this might be enough to satisfy the statute's generic requirement that applies to non-presidential campaigns, this is a presidential campaign, and there must be something more contemplated by the statute than a mailing address. To me, and I believe under the law as well, residence means the place that you live. This candidate does not live at the address he provided, nor do his nomination papers indicate that his residence happens to be in that same municipality. Instead, his filings are asking the commission to make that inference, and I don't believe that inference is provided for by statute. That inference being that some unknown portion of the mailing address he did provide happens to also be his residence. Now, beyond that, even if a candidate could satisfy the residence and post office address requirement by simply stating their mailing address, which happens to be the same city as their residence, we don't have a verified statement from the candidate challenged on where his residence actually is. So I understand the commission is not considering my reply brief, but the Elections Administrative Code section 2.053 permits the commission to consult maps, directories, and other extrinsic evidence to ascertain the correctness of any information on a nomination paper. So if the commission is not going to review my reply brief, in which I suggest that respondent owns and may reside in at least 2 other pieces of residential real estate that are outside of Cody, Wyoming, I would implore the commission to exercise its 2.053 authority to consult extrinsic evidence to ascertain the accuracy of the residence stated on respondent's nomination papers. I dispute that the case law cited by respondent helps his cause in this situation. I don't think he cited to a case that limits the definition of residence to a city or state. So that is my point with respect to count 1 of my complaint. And I'm happy to get into count 2, which relates to the timing of respondent's filing. But I'd just like to raise another point of order with respect to that. I understand the decision that was made with respect to the other complaint on this same point. So I don't want to belabor the point. I'm happy to make a record of my own arguments on that. But I just want to make sure the commission is still entertaining that question with respect to my complaint.
Okay. We will be ruling on your motion irrespective of our previous ruling.
Okay, thank you. As to the timing of respondent's filing, I don't think there's any dispute. The nomination papers were filed after 5. Even the candidate's own version of events, the filing was not in the hands of the commission until 5 o'clock plus 14 seconds. And I think respondent is relying on a strained interpretation of the statute, which reads no later than 5 p.m. I think they're asking the commission to rewrite that statute to read not later than 5 p.m. plus 59 seconds. That's not what the statute says, and it's not how it should be applied here. And as to whether the commission ratified respondent's filing by physically accepting the papers, I don't think that that's the case. Even respondent admits that commission staff openly expressed concerns about the timing of the filing, which to me suggests against the ratification having occurred. But beyond that, the administrative code at 2.053 gives the commission the right, after papers are filed, to, quote, review all nomination papers filed with it to determine the facial sufficiency of the papers filed. Now, in my view, there can be no more facial of a deficiency than the time at which a time-limited document is filed. There's nothing in the law that supports an argument that the commission's initial demeanor toward the filer is somehow forever binding on the commission to accept an untimely filed document. But if it's respondent's position that the commission made an error in accepting an untimely filed document, I think that the process should begin to correct that error to the extent any such error was made, which I don't concede. I think if the commission were to accept this logic, that any number of statutory insufficiencies in a nomination paper could be cured simply by handing that paper over to the commission. I think that the statute, which allows the commission to review papers after they are filed, encompasses a review for timeliness. And as to the commission's own safety measures, I don't think those are to blame for the late filing here. I think every other candidate and the challengers here had to deal with the same time constraints for filing and the same access procedure to get into the building. And it was only respondent who failed to deliver the papers on time. And at the end of the day, I don't think any of the mitigating factors suggested by respondent, such as momentary physical obstruction or having to call to enter the building, would have mattered had they simply done what every other independent candidate trying to get on the ballot had to do, which is afford themselves adequate time to get their papers to the commission in the 5-week time frame given to them by statute. They did not do that here, and I think the filing should be stricken as untimely. As to the third count of my complaint, which addresses specific page numbers containing circulator statements of address, my reading of the commission staff analysis and recommendations is that the pages I referenced in my complaint were already stricken, save for one. So I believe this issue to be almost entirely moot, and I will not be advancing any re-argument of those issues here today. I'll stand on my complaint with respect to that count.
Thank you. Attorney Curran?
Good evening now, Madam Chair and Election Commission and staff. As to the complainant's point on his first argument, I think that the brief that was submitted on behalf of Mr. West and his partner and his co-candidate speaks for itself, and we rely upon both the arguments made there and also the determination of staff that the high burden of clear and convincing evidence was not presented, and that the presumption of validity of papers filed should be, that the burden should be agreed to be met in this case, and that the complaint should fail. With regard to the timeliness, I'll restate my opinion that a timeliness challenge on accepted papers should not proceed under Election Code 2.07, but should proceed under Wisconsin Statute 5.06, and therefore I believe that he's deficient in that he's proceeded in the improper venue for challenging a determination of the filing officer. That said, I also think that he fails to make the substantial, clear and convincing evidence standard on the challenge itself with regard to timeliness, with just some extraneous information coming from video of one newscast or something like that. And that simply does not meet the standard that should be necessary to disqualify candidates who have taken steps to file papers with no supporting evidence besides a report. And I guess I don't need to address the third point. I don't think it's important, but certainly with regard to the timeliness, the complaint itself needs to pass the threshold burden, and I don't think it has in this case.
Thank you, Mr. Curran. Do the commissioners have questions for either Mr. Santeller or Mr. Curran? Okay. Do the commissioners have questions or requests from Mr. Judnick to offer opinions on any matter that is before us with regards to Mr. Santeller's challenge? Yes, Commissioner Knudsen.
Well, in the staff memo here, the case is made that we should reject the timeliness challenge because the complainant's case is not strong enough to meet the clear and convincing evidence standard. But my question goes back to our previous deliberation on the other complaint. Were we to enter into evidence all the same facts that we did during that hearing and carry them over here so that we ourselves established a record of a timeline of what in fact happened, then I think that evidence would greatly strengthen the complainant's case. So again, I kind of pose a procedural question here. I mean, I know I did it last time, but I don't know that we need to swear in and all of that again. But fact is, we did bring out some factual evidence in the course of the proceeding here. Could you comment on that, Nate? If you were considering everything now all in one, would this staff memo look different?
Oh, yeah.
I'm sure it would, but that's not how these generally work. I mean, these are individual complaints and responses, right? So, and it's based on burden shifting. So, based on the staff's assessment, the burden did not shift to the complainant or to the respondent in this case, where a response would necessarily even be, required. So the recommendation is that if the commission finds that based on the face of the complaint that the burden had not been met, then the burden has never shifted to the complainant, and additional evidence, the burden shifts from the complainant, to the respondent, then, it's a different kind of scenario procedurally. So that was the basis of it. If you find based on, what the complainant, included is clear and convincing, then I think it's different. Then I think the memo would go through, okay, what is the countervailing information that was provided by, the respondent here, and you would go through all those, same kind of machinations. But based on the recommendation here, where we take these, one by one, that is why, that's why I didn't think it was necessary in this case. I hope that makes sense.
If I may, Madam Chair.
Thompson, go ahead.
What I thought was important about this, and this is addressed to Mr. Knudsen, is, it's at page 5 where the staff says, in quotes, a news article stating that a candidate's papers were not timely filed simply does not meet the burden of proof. And I think that's the issue. I mean, we don't want to set a precedent that if there's a news article that says someone's late, that's sufficient, clear, convincing evidence. I mean, I think that's a sound recommendation. Clearly, if we incorporated all the facts that we know, the decision would be different. So we can say that this complaint is denied because he didn't do it, and we can still say that it was untimely going forward, just so everyone knows. Don't send us a complaint with just a news article.
Madam Chair.
So I have a somewhat different view about this, which is as follows. If, for example, the staff were to miss something glaring in their evaluation of papers, Mickey Mouse is the circulating person who circulated the nominating papers. Somehow they missed it. And a challenge says, I don't think Mickey Mouse was the circulator, without anything more. I don't know that as a commission, we would be obligated to ignore the fact that Mickey Mouse was very clearly not a circulator, simply because the challenge itself didn't have an affidavit from Minnie saying Mickey was elsewhere. In this case, we have a motion to strike the papers as untimely. we have already just ruled they are untimely. And I think we're placed in a rather perplexing position to then say that we're going to deny the challenge because the evidence as originally presented didn't rise to the level, even though now it does. And I think it is a struggle to ignore everything that this commission has simply gone through for the past 2 hours to do that. So I am troubled by the idea that, if we look at 2.05, which says we're allowed to look at extrinsic evidence, we have a whole lot of it now. Why we wouldn't do that? And I recognize what staff did here, which I think is right, which is there is some moderate level at which a complaint has to be sustained, but I don't think we're bound by that at the point where we have all of this information before us to then say no to the challenge when the challenge appears, based on our previous vote, to be an accurate one.
So if we're going to incorporate the rest, then you or Dean suggest the motion, because it would have to be modified to include and incorporate all the testimony and facts of evidence that we've decided to date, and based on everything, it was untimely. If you're trying to avoid an inconsistent press release of this, which I could see that makes a lot of sense, because people may not read between the lines and understand the nuance. So I would be comfortable with going that way too. I mean, clearly they were untimely, and we decided that already.
So I think the motion I would make would be, based upon the record of the proceedings held before this commission today, including the testimony of the Wisconsin Elections Commission staff members, the commission sustains the challenge to all nomination papers submitted by Mr. West and Ms. Tidball because they were not filed timely in accordance with Wisconsin statutes 8.20 sub 8 sub AM, and therefore their names shall not appear on the 2020 November general election ballot as independent candidates for the president and vice president, respectively, in Wisconsin. Commissioner Knudsen.
Might be splitting hairs, but Mr. Santeller didn't challenge Miss Tidball.
I will accept that amendment. Is there a second?
Sure.
Okay. Is there a discussion on that? Commissioner Spindell.
Yeah, I'm not going to go and repeat everything that I repeated before, but I'm not sure the example that you gave was a good one, because if we go back to December 2011 with the Scott Walker petitions, Mickey Mouse and Adolf Hitler were allowed to be counted on the recall petitions, as long as they were properly dated and included a Wisconsin address. So I think Mark has a lot of good points here, that we should not base something on a news report that would start it to be a very bad precedent. So I would be against, I would originally go with a recommended motion of the staff and not change that.
Obviously, those petitions were not before this body. Any other comments from the commissioners? Commissioners Bostelman or Glancy, do you want to be heard? I just think we need to be consistent, and we can't ignore the evidence we've heard. It would be a rather bizarre ruling for us to do that. All right, any other discussion?
Is there a motion on the floor at this point?
There is.
What I'd like to make a friendly amendment again, that since the motion 1 be considered after motion 2 and 3, the 2 and 3 be combined into a motion, and then 1 be the second motion.
Well, I already made one as a separate motion.
Okay, and what I'm doing is a friendly, oh, you're just doing number one, right?
I am only doing number one.
Oh, okay.
And it reads, do you want me to read it again, Bob?
No, that's fine. And then you're going to go on to 2 and 3, is that it?
No, Bob.
Okay, that's fine.
Bob, I'm not making the written motion.
Bob, there's a new number one.
I know that.
Okay.
Okay. All right, so the recommended motion is based upon the records of proceedings held today before this commission and the evidence presented. The commission sustains the challenge to all nomination papers submitted by Ms. Tidball because they were not, Mr. West, because they were not filed timely in accordance with Stat 8.20 sub 8 sub AM. Therefore, their names shall not appear on the 2020 November general election ballot as independent candidates for president and vice president, as candidate for president in Wisconsin. That is the motion. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Aye.
Commissioner Spindell.
No.
Commissioner Thompson.
Aye.
All right, the motion is carried 5-0.
You're not.
5-1, excuse me.
Okay.
You are correct, Mr. Spindell.
Madam Chair,
Yes.
I'd like to move that we adopt the staff recommended motions on page 6 and 7, numbers 2, 3, and 4.
I'll second that.
There is a second. Is there further discussion?
Yeah, let's. 2 is the timeliness. Dean, we just changed it.
Oh, I'm sorry.
I think you meant.
I misspoke.
I think you meant 1.
1, 3, and 4.
Right.
Yeah. Okay.
Okay, so it is numbers 1, 3, and 4. And there's someone seconded that?
I did. Mm-hmm.
Okay, Commissioner Spindell seconded that. We will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
The motion carries 6-0. All right. We will now proceed to the final challenge, which is the complaint of Alan Arntzen against the Wisconsin Green Party, Howie Hawkins, and Angela Walker. It is my understanding that Attorney Mandel will be presenting for the challenging party, and Andrea Merida will be responding on behalf of the Green Party, Mr. Hawkins and Ms. Walker. As with before, each party will have 10 minutes to present, followed by questions from the commission. Attorney Mandel, as the challenging party, you may proceed.
Thank you, Madam Chair. Before we begin, I have a point of order again.
You may.
Thank you. Like with my point of order about the reply briefs, I do understand that I've raised this with staff who have consulted with Administrator Wolf and yourself. I do not expect the order to change, but I do want to have this on the record. It is our position that the respondents in this matter have forfeited the opportunity to present any arguments today. Where the rules grant an opportunity for argument and the party forgoes that opportunity, then forfeiture is the result. The Supreme Court has held that quite clearly. For example, I would point to the Ndina case, Ndina, at 2009 WI 21, which in paragraph 29 says a failure to make a timely assertion of a right results in a forfeiture. The rules of this commission set strict deadlines for complaints and responses. I would point to Administrative Code, Chapter EL, Section 2.07, Subdivision 2, paragraphs A and B. To allow the respondents to present arguments here today without having filed a response as required by the rules would give the respondents nearly 11 times as many hours to prepare as were given to the complainant to go through their papers, identify the problems, research them, substantiate them, and get them on file with this commission. It allows the respondents to sandbag the complainant by presenting arguments with no notice whatsoever of what those arguments will be and no opportunity to prepare. It prejudices the complainant's efforts to meet our burdens under law of proof and persuasion. Administrative hearings in this state must comport with due process. The Supreme Court has so held. For example, at the Union Bank case at 142, Wisconsin 2nd, page 126. And as I said earlier, due process is about fundamental fairness. We believe this is an imposition and a prejudice to the complainant, and we just want our objection noted for the record. I would also ask that the chair confirm my understanding, based on my exchange with staff about this earlier, that while the commission is going to allow the respondents to present argument, they will not be allowed to present any evidence that should and needed to be presented earlier if it was going to be presented at all.
So this question of procedure was raised with staff and with the chair. My analogy in this situation was to summary judgment motions, which I think is applicable, which is to say one is not required to provide evidence to rebut such a motion, and one is permitted to argue the law and argue that the law is not applicable or that the petitioning party has failed to comply with the necessary law. And I believe the Green Party and Mr. Hawkins and Ms. Walker have the opportunity to argue, by way of example, Mr. Mandel, that your papers were untimely or improper or don't meet the necessary legal threshold. However, as I indicated to staff, who I believe did transmit this to you, I believe the proper interpretation is that they would not, by way of example, be allowed to come in today and offer evidence that should have been submitted in a verified format with an answer to this challenge. And the staff memo refers to that, to the fact that there is not any evidence in the record from them. So they will be permitted to argue, but to the extent that they make any factual assertions that are not in the record before us, that they're kind of out of luck on that one. If at the end of their presentation you feel that there is something of such great seriousness that you require a brief additional time to rebut their arguments, I will allow that. So I will return to you after Ms. Marita's arguments. However, not to repeat what you have said previously, only to address something that is raised for the first time in their comments to the commission. Commissioner Thompson.
I'm just trying to get the lay of the land procedurally here. Are they limited to admitting that the facts of record are them? I mean, they can't come in here and deny all the facts, right?
I think they have lost that opportunity, and I think that's what Attorney Mandel is stating, that by not submitting anything in contradiction of the facts, that Attorney Mandel is entitled to come in and assume that those facts are not in dispute.
Yeah, because if we're going to use summary judgment and I don't submit facts that refute, I'm admitting those facts. So if the argument is that here are the facts, this is the case, assuming these are the facts, I still win under the law. Is that what we're allowing?
I think that is the only fair way to do it. I do agree with Attorney Mandel that if parties were to come in today all of a sudden with all sorts of new facts that they didn't submit in a verified response, that would be improper and it would be prejudicial to the challenging party. However, they are entitled to come in and argue the law and argue that even if the facts are true as stated or the information is true as stated, that they should survive the challenge for whatever reasons they wish to offer. So my view is we will not limit their argument, but that they are not able to submit new facts because they did not do so by the time set forth by statute.
Or dispute facts, right?
Or dispute facts that are in the moving papers. So, does that clarify, Mr. Mandel?
It very much does, Madam Chair. I greatly appreciate it.
Okay. Madam Chair, if I may.
You may respond to the point of order, Ms. Marita.
Right, thank you. My name is Andrea Merida. I'm the campaign manager for Howie Hawkins 2020. I have to point out that even though your statute refers to calendar days in the response, We do need to be clear of the fact that 2 of those days are over a weekend where business cannot be submitted. And your staff will confirm that when I actually received notice of this challenge would have been 7:37 p.m. Wisconsin time. That was 5:37 p.m. Denver time, where I live and where I receive email. So technically, we actually have not even been noticed in a proper fashion. And actually, that notice, the clock for that notice really should have started on that following Monday. Thank you.
Thank you, Ms. Morita. I would let you know and let our fellow commissioners know that in Wisconsin, that if a time limit is set for less than 10 days, weekends are counted. And that is actually state statute. If a time limit is greater than 10 days, then weekends and legal holidays are excluded.
And if I may respond?
Briefly.
Okay. Well, again, I mean, earlier we've heard arguments that, you know, there's the time clock of 5 o'clock with seconds, and that was not sustained by you all. So that by that logic, then I have to ascertain that if you're sending me something official after 5 p.m. on a weekday or on whatever day it is, that actually that calendar is not going to start, and our time should not have run out on Monday. It actually should have run out on that following Tuesday, because you conducted business after that window. So if one thing is true, then the other should also be true. If business conducted after 5 o'clock p.m., your time is the boundary, then really that should apply here as well. And so we have not been given sufficient time under statute to respond to this. Thank you.
Ms. Morita, did you file anything on Tuesday?
Did we file anything on Tuesday? We were told that we could not.
Okay, thank you. All right, Attorney Mandel, we're going to give you 10 minutes. Commissioner Administrator Wolf will be beginning the time. Go ahead, please.
Thank you, Madam Chair. The campaign from Mr. Hawkins and Ms. Walker submitted nomination papers with 3,880 signatures. So many of those signatures are invalid that they do not meet the threshold of 2,000 signatures to be included on the ballot. Wisconsin statute requires that nomination papers must include the candidates' addresses. That's in section 8.20, subdivision 1, paragraph A. The Wisconsin Elections Commission has on its website a document called Nomination Paper Review Guidelines. And it's exceptionally clear. On page 1, it says, quote, "The header of each petition page must contain all the required information. If any of the required information is missing or incorrect, no signatures on that page can be counted," end quote. That same document on the same page expressly lists, quote, "residential address of candidate," end quote, as required information. Here, there are a number of pages on which the residential address for Ms. Walker is incorrect. Those pages and all of the signatures on them cannot be counted. The respondents actually created this problem by ignoring the guidance that the commission staff provided and refusing to correct the error. I would point the commission to page 31 of the staff memo. The staff expressly instructed the respondents not to make any changes to information in the heading of the pages after electors had signed them. In addition, the staff sent 2 emails on 2 successive days, both quoted at length on page 31 of the staff memo, with instructions to help the campaign avoid any issues that could be caused by Ms. Walker moving from one residence to another during the period that the nominating papers were being circulated. The Green Party failed to provide the minimal information that the Elections Commission staff requested. As a result, it submitted incorrect nomination papers, and then when that was pointed out by our complaint, as we've already discussed, they failed to fix the issue or file minimal information that would have allowed the commission to understand what had happened. Now, It is simply too late for the respondents to fix those oversights. The staff memo makes that point at page 32. The respondents fall short under either of two approaches to counting invalid signatures. Both approaches are laid out in our complaint. The first approach is that there are 2,019 signatures on nomination papers that are printed with the incorrect address for Ms. Walker. I will note that that 2019 is a slightly different number than is in our complaint. Our complaint erroneously states it is 2046. It was a math error, and I apologize. There are 2,019 signatures on nomination papers that are printed with the wrong address for Ms. Walker. If we remove those 2,019 signatures from the 3,880 total signatures that the respondents submitted, there are 1,861 signatures remaining. That is insufficient to meet the requirements of section 8.20 subdivision 1, paragraph A of the statutes. There's another way to think about this, and it's a way that I think the staff prefers, because just to be clear, not all of the papers have one address or the other. Some of the papers have an incorrect address for Ms. Walker that is printed on the papers, and then there are handwritten efforts to correct that address. So there are 1,834 signatures on uncorrected papers with the wrong address printed. In addition, there are 57 signatures on pages that have the wrong address for Ms. Walker printed, and where the handwritten correction was made after the date on which the electors signed the paper and the paper was certified. Those should not be counted. That is what the staff guidance was to the Green Party in advance, and the staff memo recommendation concurs with that at page 32. In addition, there are another 48 signatures on pages that have the wrong address printed, where the signature is corrected by hand without any attempt to verify, no initial, no date. It is complainant's assertion that those should not be counted. The staff memo, I will note, disagrees with us at page 32, but that seems to provide an incentive for candidates to provide less information and not to be fully transparent. It seems perverse in many ways to discount information where the date provided is later, but to allow those pages where there's no date provided at all. And I understand that we bear the burden by clear and convincing evidence of proving that there's a problem, but there is no possible universe in which we could know when those handwritten corrections were made. That's simply an unreasonable standard. Regardless, if we start with the 1,834 signatures that are on uncorrected papers with the wrong address printed, and we add only the 57 signatures where the correction was clearly made and dated after the papers were complete, then we would be striking 1,891 signatures. And when we remove 1,891 signatures from the 3,880 signatures submitted, again, respondents are short of the 2,000 signature threshold that they need to meet to be on the ballot. I would, of course, continue to maintain that the other 48 signatures on those pages where the corrections are not dated should also be removed, but that really, now we're just arguing about how far short they fall. They fall short if the commission strikes all the signatures on papers printed with the wrong address. They fall short if the commission strikes only those signatures on uncorrected papers that are printed with the wrong address, plus those few signatures that were on papers that were printed with the wrong address and corrected in an untimely, belated fashion after they had been signed. Either way, the complaint should be sustained, and Mr. Hawkins and Ms. Walker should be stricken from the ballot. I will look forward to answering the commission's questions, but I have no further argument at this time.
Thank you, Attorney Mandel. Ms. Merida.
Well, thank you to all of you commissioners and Madam Chair, and to staff and to Mr. Mandel as well for making the time this afternoon. to hear what we have to say. You know, I want to start out by saying that it's crystal clear that Wisconsin voters want the Green Party nominees on the ballot. We submitted 680 pages containing some 3,966 signatures of the nearly 6,000 that we actually collected, and we're willing to submit the excess for review. Now, it matters very little to a voter who resides in Wisconsin what is the actual address of a vice presidential candidate in South Carolina. A change of address, especially within the same city of Florence, South Carolina, does not speak to the constitutional qualifications of the candidate, which in this case are clearly met. I want to point out as well that in 1980, independent presidential candidate John Anderson submitted a Wisconsin petition showing Milton Eisenhower as his vice presidential running mate. Milton Eisenhower was only intended as a stand-in. After the petitioning deadline on August 27th of that year, former Wisconsin Governor Patrick Lucey became Anderson's real running mate, and Lucey appeared on the Wisconsin ballot. If Wisconsin allows the running mate on the petition to withdraw and to be replaced by someone else, surely it does not matter that a running mate moves down the road in the same city she lives in South Carolina. Unlike the assertions made public in other cases that the commission reviewed today, neither the Hawkins-Walker campaign nor the circulators working on our behalf made any attempt to hide Ms. Walker's current address, and that's evidenced by the manual changes made to some of those petition forms. Once we became aware that the resident's address might be an issue, Ginny Lester from our campaign emailed the elections help desk on July 27th. And I want to point out what's already in the analysis from staff. Robert Williams, the election administration specialist, gave her instructions on how to proceed. His instructions were to file a new declaration of candidacy with the changed address. We do actually have a copy of that changed declaration of candidacy. Based on Mr. Williams' email, where specifically he states if the move and address change occurred after all of the petitions have been circulated, they will reflect correct information at the time of circulation. Our petitioners began changing the petition forms and including the new address. On July 28th, we received an email again from Mr. Williams, which instructed us not to change any of the information in the headers. On July 29th, Mike McAllister of the Wisconsin Green Party received an email from Mr. Williams instructing us to A, not change any of the information in the petition sheet headers, and B, filing a direct declaration of candidacy with an amended address was optional since, and I stress, and this is a direct quote from that email, federal candidates are not required to list an address on their declaration of candidacy. We feel that we've exercised more than enough due diligence in attempting to rectify the potential issue with the change of address, even though the Election Commission staff have asserted that listing an address for this presidential ticket is not even required. In summary, we've shown through our petitions that Wisconsin voters want the Green Party on the ballot. When the vice presidential nominee moved down the road within Florence, South Carolina, in the very same municipality, we notified the staff and we followed their directions. Voters should not be denied the right to vote for the Green Party ticket for following the directions of the Board of Elections, the Election Commission staff. If additional signatures are needed, we have thousands more that the board can review, but we've already shown that voters in Wisconsin want the Green Party on the ballot. And I'll just stay there. Thank you.
Thank you, Ms. Merida. Attorney Mandel, is there anything in Ms. Merida's submission that you wish to address, limited to those things which are new or you did not previously address?
Yes, Madam Chair. I just want to note that in Ms. Merida's argument, there were several factual assertions that are not supported in the record, are not verified by the candidates, and should not be considered. When petitioners took certain actions, changes in the declaration of candidacy form, mentions of a July 29th email that is not email between the staff and the campaign, that is neither in the staff memo nor in the record, a mention of a notice to the staff of the Elections Commission of the date on which Ms. Walker moved, references to supplemental signatures that were not filed. The memo itself says that there were not any supplemental signatures filed by the deadline. That's on page 29 of the memo. All of these are factual assertions, and by the ruling of the chair earlier, they are out of order, and they should not be considered. Lastly, I understand the will of the electors argument that Ms. Merida wants to make here, but I will return again to the February 27th, 2020 motion that this commission passed. I'm looking at the materials from that meeting. I'm looking at paragraph 1 of the motion. It's on page 29. Quote, "The will of the electors language in Wisconsin statute, section 5.01, subdivision 1, does not apply to the review of nomination papers and election petitions." The commission is not to take those things into account. To be clear, as the commission knows, I disagreed with that position in the Sullivan matter that was decided by the commission in January, and I took the opposite position. I lost. Not only does the decision make that clear, but then the commission passed this motion at the end of February to cement and clarify the law about what the rule is. That is the rule, and it's the law in Wisconsin. Thank you.
Thank you, Mr. Mandel. Do any of the commissioners have questions for either Ms. Merida or Mr. Mandel?
You see me?
Well, Commissioner Spindell first, and then Commissioner Knudsen.
Okay. Ms. Mandel, she made, I'm sorry, how do you pronounce your name again? Make sure I get it right.
You're referring to me?
Yes.
Merida.
Merida, okay. And this question really is to Megan. Some of the facts that she indicated there of correspondence back and forth between their campaign and the Wisconsin Election Commission were not made part of this record. Is there any reason why that wasn't done? This to Megan, if I could.
I believe that we included all relevant emails to the discussion as part of the staff memo. So if there were others beyond that, I don't know, Nate, if you want to speak to what was included.
I can certainly speak to that. Ms. Merida mentioned an individual that I did not know Mr. Williams had a conversation with. That is absolutely true. And this is part of the issue with not having a response, because we were not aware. I was not aware of that. Robert may have been, but I was not. I was aware of the emails that were included based on this topic, because I was copied on those emails. So that's why I was aware of those. That's the honest, the answer of why that's the case.
Okay, so basically, and I guess I still don't understand the answer to my question. What Mrs. Miranda indicated was that over a period of time, they corresponded with the Wisconsin Election Commission, had questions answered, things along that line, which should have made everything smooth, I suppose, or at least that's her allegation. And for some reason, it appears that this was not considered. Is there a reason for that, Megan? Are you saying that we didn't get a lot of these emails and so forth and so on? Or?
Again, we included all relevant emails that were relevant to the question or that Nate was aware of.
That's fine. And these are, this is a very interesting situation. So I did actually go through and I looked at every single page of the various names and things along this line. And it appears to me that on its face, that this whole document, taken as a whole, very clearly indicates that the vice president candidate, Angela Walker, apparently had a residence at the TV address until July 30th or July 31st. Then it appears a new residence was established at the Royal Street address. It appears that the Royal address became a new resident on July 30th. Is that about right?
Commissioner Spindell, that information is not before the commission. That's the point of order we had previously.
Well, I think that is before the commission because that's in the thousands of pages that they submitted. And if anybody takes a look at it, it's very clear that none of the signatories were deceived in terms of what the address was. The dates are such, and I agree that there was a few of the petition pages actually, where, as Mr. Mandel said, they might have been signed where there were some people that were not, when they signed it, did not have the correct address in front of them. But everybody who signed it had the correct address of where this vice presidential candidate lived. And unlike a lot of the petitions that we get, especially the ones to contrast to the West campaign, which were, to me, sort of were not as good as they could have been. These were very well done, very carefully done. It showed me that they were checked out, and taking the whole situation on its face, to me, it was extremely clear that all the signatories signed the agreement knowing where this vice presidential candidate lived, which just happens to be 4.6 miles between these two residents. Obviously, she's in Florence. Florence, is that about right? 4.6 miles? Is that about correct?
Again, that's not in the record. And I have Ms. Merida that's allowed to argue the law. Okay. She is not allowed to introduce new facts that should have been introduced by a verified response.
Okay, but it's what I'm saying, that information is in the record. It's in the record by itself, by anybody that takes a look at and goes through page by page on these various petitions. And again, and she mentioned this. I think this is a good point. Angela Walker is a Milwaukee native, former Milwaukee County Transit bus driver. She was an avowed social justice advocate and wants to give the black and brown people another opportunity to do it. So this, again, is another example of suppression by the Democratic Party of Wisconsin, which is the plaintiff in both of these situations or in these challenges, trying to tell the blacks and the Hispanics and whomever how to vote, that you should not have a choice between only Biden or only Trump. No thought about West, no thought about the Green Party candidates. And I think that is just another example of suppression of the black vote. It's a black choice. And, I don't know, does it meet the definition of systemic racism? I don't know. But
Commissioner Spindell.
Yeah.
I'm sorry, if I may, it is a factual matter. The Democratic Party of Wisconsin has nothing to do with this complaint.
Well, who's the guy that wrote it? He's the political director for the Democratic Party of Wisconsin, isn't he?
Mr. Arntzen? First of all, I wrote the complaint.
Well, of course,
as an attorney. Yeah. And Alan Arntzen does not work for the Democratic Party. Alan Arntzen is a retired lawyer at Foley and Lardner.
Madam Chair.
Okay, I'm sorry. I thought it was the political director of the Democratic Party.
We're allowing Mr. Mandel to make comment.
Nope. Commissioner Knudsen asked to speak next. Commissioner Knudsen, do you have any questions?
Is there a reason why you're allowing Mr. Mandel to speak out of turn, and I'm not allowed that same opportunity?
He was addressing a specific thing Mr. Spindell said.
Well, I was asked a direct question, ma'am.
And I'm not allowing additional facts to be presented here today.
Mr. Spindell is asking about Angela Walker's current address and the distance.
It is not a fact you are permitted to put on the record, ma'am. You lost that opportunity when you failed to file, as instructed by staff, a verified response. You are allowed to argue the law. And now Commissioner Knudsen is available to ask questions of you and Mr. Mandel. Commissioner Knudsen, go ahead. You have to unmute yourself.
Thank you. Sorry about that. Thank you, Madam Chair. And before I ask my question of Ms. Merida, my question for Nate, our staff counsel. Can you clarify for me, Nate? There's a time period during which correcting affidavits can be filed to correct errors on the nomination papers that are made by either the circulator or the signer. Did that afford the candidate an opportunity to clarify or correct the header?
So the correcting affidavits need to be filed. Could you correct information in the header? I can read the statutory or the admin code site for you. So any information which appears on a nomination paper is entitled to a presumption of validity. Notwithstanding any other provisions of this chapter, errors in information contained in the nomination paper committed by either a signer or a circulator may be corrected by an affidavit or of the circulator, an affidavit of the candidate, or an affidavit of a person who signed the nomination paper. The person giving the correcting affidavit shall have personal knowledge of the correct information, and the correcting affidavit shall be filed with the filing officer not later than 3 calendar days after the applicable statutory due date for the nomination papers. That's the code section that deals with correcting affidavits.
Okay. And then could you walk me through, Nate, this timeline that came up during the point of order, the timeline of the complaint was received in the evening on a certain day, and then the candidate was notified of the complaint, I assume by email.
Correct.
And when the timeline starts for the statutory allowed time for a response. Can you tell us that just in some detail?
Sure. So the filing deadline was August 4th, which makes the challenge deadline due August 7th at 4:30. We received the challenge on August 7th, just before 4:30. Once we received the challenge, we received all of them right around the deadline. We process them, we scan them in, we figure out who the contacts are for all of the candidates and the campaigns, and then we bundle them up, put them in an email, and send them out to the contacts that we have. That happened within an hour or two after receiving the complaint. Under the admin code, it actually addresses the amount of time that we have to actually get the complaint to the person that is being challenged. Filing officer shall make arrangements to have the challenge delivered to the candidate within 24 hours of the filing of the challenge complaint. We, in this age of, email, we try to do it that way, easiest, and we received, confirmation that it had been received. So we had assumed that, and we provided the information, on how to respond. We provided the standard. We have a challenger memo that goes along, a cover memo that goes with all of the challenges, explaining the deadlines, the process, how to respond. If you want to respond electronically, if you want to respond via hard copy, these are the instructions, and that was all sent out. The time came on Monday, so Monday at 4:30 would be the deadline for challenge responses to be received, and we did not receive a response. I did have a phone call with Mr. Schaub of the Green Party the afternoon on that Monday, asking about a response. I provided him the exact same information. I had told him that I had been in contact with Ms. Merida over the weekend. She was asking questions about whether, what the options were. Can I file a response and appear? Can I appear and file a response? Is it a mix or match situation? And, the conversation was, you have the option here. I'm not going to give, essentially the legal advice, but here is what most candidates do. Candidates file written responses and they appear at the hearing. That's how you respond to challenges to the nomination papers, and that's how it is done. So that is what happened. I talked to Mr. Schaub of the Green Party on the afternoon. Like I said, I indicated I had a conversation with Ms. Merida. He said that he was going to reach out to her to see if there was a response or if they would coordinate a response, and that's the last I heard. 4:30 p.m. deadline passed, and we had not received a response from anyone. That is the timeline.
Okay. Well, Ms. Merida, my question was originally going to be for you, and it was that, well, So by administrative code, the staff had 24 hours to notify, and by choosing to notify essentially as soon as administratively feasible late on a Friday, that meant that 2 of your 3 days were weekend days. And I mean, I understand that struck you as probably not completely fair due process. I understand that, but I think that is the way our system has worked. I mean, was that your case that, hey, we knew, but we didn't know? And because the failure to file a response is all but fatal in these cases. I just tell you, it's almost fatal. It's very difficult.
Well, Commissioner, thank you for that. This was actually presented as an option to us by Mr. Judnick. He stated so just before you came back on to speak. So that's the situation. If you tell me that I have an option, then I'm going to take an option that is more amenable to me, given the constraints of the time, especially under the pandemic, especially given the fact that I have one candidate in Syracuse, I have another candidate in Florence, South Carolina, and logistically, it is untenable. It is logistically burdensome for us to comply with a statute that was written not contemplating the pressures of a pandemic. I would say too that the email traffic that was talked about in the statement is actually not the complete email traffic. Mr. Judnick was CC'd on every single one of those emails, and it's been only selectively applied. And so you don't actually have the full transmission of information. And again, even if you look at the instructions that were given, that were listed in the staff's response, we still complied with their instructions. There was no intent here to defraud anyone. And certainly, when your administrative rules talk about change of a correct address, that burden is typically put on a person that signs a petition. And, when we're told by staff, which is also on the record, which is also something that Mr. Judnick was copied on, that it's technically not even necessary for the federal candidate to even have an address on file, then we have to operate in the way that we're being instructed. You're typically, the reason why you have a candidate's address on a nominating paper is to show the signer of that petition that candidate lives within the jurisdiction. We know that Angela Walker moved. She moved within the same city, but her jurisdiction is the United States of America. So it's not like she moved overseas and then was attempting to complete her candidacy. She still lives within the same jurisdiction. And so while I appreciate, the efforts to try to be accurate, and those are something that as a Green Party member, I support 100%, because I want our elections to work for us. But what we're talking about here is a splitting of hairs that essentially is going to deprive many, many people of their democratic choice, their democratic voice, not just Black people, not just Latinos like me, but anybody else who doesn't want to stay within the confines of the duopoly choices. So, we have done everything that is necessary to comply with all of the instructions that were given to us by staff. You have documentation. The candidate statement was submitted with the petitions, but for some reason the staff didn't recognize that. I have a copy of what was submitted. So this is a very, very interesting way for Mr. Mandel and for the party that he is representing to try to curtail the democratic voice of citizens of the United States who are going to be voting for another citizen who resides in the United States, which is the jurisdiction of that office.
Do any other, Commissioner Clancy, go ahead. Oh, you have to unmute.
Okay, I guess my question is for Nate. What is the procedure when a candidate moves during the nomination paper time frame? if I start circulating and I move and I continue circulating, is there a process? I mean, is there paperwork that needs to be filed? Is there something, because we have nomination papers with 2 different addresses on it. So my question is, what would make that legitimate or not?
The rule would be to ensure that when individuals are signing the nomination papers, that whatever is appearing on there is accurate at the time they are signing it. I mean, that's the advice that we give. I mean, there's nothing that prohibits, obviously, a candidate from moving. That happens. But you need to make sure that whatever is in that header, that's the information that is being presented to those individual signers, and they're making their choice as to whether they're going to support that candidate's nomination. That information is accurate, and part of that is providing an accurate address. And so if a person would move, if there was a certain point at which the person moved, you could certainly have, and we had this in the last round. We were discussing this in the office, the last round in June. You certainly had a candidate that had moved, and they filed nomination papers. The papers got to a certain point. They amended information. They amended a declaration of candidacy with us, because that kind of shows, okay, this is they're swearing to, this is my present address. This is where I reside. And then everything going forward was, containing the new address, and signatures were valid with, after that new address was on that paper. So it can certainly be done. The main issue here is that we just had no idea. We have no idea because there was no written response. And there was definitely enough question here that there were issues with what is the correct address. We can't tell, and we couldn't tell, especially when we have the declaration of candidacy that Ms. Walker is talking about contains the 315 Royal Street address. I mean, that's what's on file, with the commission, and that's what went into the recommendation as well too. When there were arguments saying that one address is valid and what's not, we have a sworn document here saying that's what the address is. So that also plays into kind of what the recommendation was from the staff. The biggest point. Yep. The biggest point is that we just there was no statements in the record as to what happened. Had there been an affidavit saying maybe they moved on this certain day and this is why, maybe that would have been certainly helpful, but that's just not in the record.
Madam Chair, if I may.
Just wait for a moment. We'll see if Commissioner Glancy has additional questions for Ms.
No,
Merida.
I'm good.
Okay. Briefly, Ms. Merida.
So basically what Mr. Judnick is saying, and by showing us this document on the screen, and that says 315 Royal Street in Florence, South Carolina, what he is saying is he's affirming what I have said, which was that the instructions that we got from staff was that we were to file a new declaration of candidacy with the correct address. We were instructed not to change anything in the headers, even after we first received instructions that we could. So what he is saying, he is affirming what I'm saying, that we performed due diligence and followed the instructions of Election Commission staff by filing the very document he just showed us in the screen with the petitions that we filed. I think that we have done everything that the commission has asked us to do.
All right. Ms. Glancy, yes, Commissioner Glancy.
Okay, just to follow up then, do we have one declaration of candidacy or do we have two?
This is the only declaration of candidacy that we have.
All right, thank you.
Okay.
It also indicates that it is not an amendment. The box is specifically checked.
May I address that?
Briefly, Ms. Merida.
Your deadline for accepting a declaration of candidacy is actually at the time of submission of petitions. So you may not have received one before then. And given the fact that you already knew that there was an issue with the change of address, you were notified of that.
Madam Chair.
Commissioner Knudsen.
I do have a problem with, and just skipping, kind of cut to the chase, on the bottom of page 32, the staff motion dealing with the challenge to the 1,834 signatures that were printed and circulated with an address of 3204 TV Road. I don't see any evidence that that was an incorrect address at the time that those were being circulated. And so while I can agree with there are other challenges here in the subsequent motions that I can agree with. It got messed up. There were cross-outs and a variety of things. But it seems to me, given the circumstances, we know she moved. We know she moved from one address to another address. We have no evidence that says this was incorrect at the time that these were being circulated. Man,
well, I think one of the issues is that we have nominating papers dated the same day at two different addresses, which is impossible.
It's not impossible. There is always a day when you moved, and there are circulators out there.
Well, the thing is that the circulators, it still has to be accurate. And I don't know that staff went through to evaluate all the overlapping signatures because, I mean, I think the issue is that the challenge was made that there was a sworn statement that that was her address. And the challenge is we have a sworn statement saying that's her address. And we have all these petitions that say it's not, or they have something else at the top. And a single affidavit stating I moved on such and such a date would have solved this because and inexplicably they decided not to do that. But we have a sworn statement stating her address is something other than, put your hand down, Ms. Marita, please, I'm speaking. We have a sworn statement saying her address is something else other than what's on these papers. And I mean, I think there's a very credible statement that when someone swears that's their address, that's their address. And otherwise, we have a bunch of papers that have some other address that was solvable under oath with a single affidavit from Ms. Walker, and she didn't submit it. So you're assuming that it was correct at the time, and Ms. Merida's trying to get that information into the record, but it's not before us. We have no way of knowing what her address was on that date if she doesn't tell us.
Okay, can I follow up?
You certainly may.
I mean, my only assumption here, because there was no response, the only thing I have is from looking at the staff memo. The staff memo says, pretty clearly that there was this issue with her having moved. And so the only way I know that she moved is not because she told me she moved, it's because staff told us she moved. She didn't bring that into the record for me because there was no response from her. I knew nothing about what was going on with her other than what staff told me. And they clearly were aware of what's going on. And so, I mean, the fact is, I don't see any evidence that those 1,864 signatures with her former address, that there's any problem with those. I mean, I think our normal standard, one more sentence. Mm-hmm. Our normal standard is give kind of a presumption of validity. And I don't see why we aren't applying that presumption of validity to that group. There is no crossing out on that group. There's only the question of, was that her address at the time before she moved? It's a 5-week period. That's the question. And they have to be given a presumption of validity.
But I think we know that we don't know that. First of all, we don't know if that was her address. We don't know, even if we know that she moved at some point, we have no idea when she moved. We don't know anything like that because inexplicably they chose not to tell us. And this was solvable with a single affidavit, which even in the days of COVID is not hard to get. You get one affidavit that says this was the date. If we had that, and this is, I think, part of Mr. Mandel's thing, if we had a response the challenger could come in and say, if that's the date, here's the signatures that count and here's the signatures that don't out of each group. But if we don't even know the date of the move, the challenger's left in the dark and can't even effectively deal with that. So she may have moved, but what address was she in the beginning? We don't know. She swore that her address was the other address. That's under oath. And so we're left with signatures under oath or an address under oath and a challenge. And all they had to do was do an affidavit saying, here's the date I moved, which would have allowed the challenger to effectively address that petition. Because if you look at the petition papers, they overlap. They are not all on before a date, and they're not all after a date. There's a big mishmash of dates. Commissioner Spindell.
Yeah, just a couple items. One, right now we're not holding a court hearing. This is an administrative hearing. I've been to a lot of administrative hearings where hearsay and other information and things along that line are not allowed into the record. In an administrative situation, information such as this is. I was fully expecting today to have I figured that the party felt they didn't need to respond since everything was so obvious. And I did. I personally went through every single page of those petitions. There are very few ones that are messed up. The overwhelming majority, and it's probably, if they did, almost 4,000 of them, 3966, I bet you well over 3,500 of them, the person that signed these particular, and probably more than that, even more than that, but there's some other mistakes on them, knew what the address was when they signed them at that particular date. Now, I expected her to come in today and say, or the candidate or Angela or whatever, come in and say, yes, I moved from TV over to Royal on this particular day. It's very clear. And as Dean just said, there was not very few, if any, signatories that were people that signed it that were misled in terms of that. And I think that in a situation like this, that we need, for the sake of the public, which is watching this now, I suppose, and the newspapers, that we hear what the answer is and what the real facts of this matter are, rather than trying to have some technicality close this hearing down. Because this is not a court hearing. This is an administrative hearing.
Madam Chair, if I may.
No, you may not. I'm going to allow the commissioners to ask their questions. Do any other commissioners have questions for the parties or for Attorney Jutnick?
Well, I guess my question is to you. Am I right in assuming that this is not a court trial and that this is a administrative hearing and that additional information such as is quite relevant? I know when she moved. She moved on the 29th or the 30th. From looking at this, it's very clear in this whole document. I felt it was so clear that I didn't even need to ask a response, but I thought that she would come in. And I think, for the record, whether the commissioners want to consider it or not, that she has the right to come in and tell us what she knows about this situation.
She had the right to present it. They chose not to.
I'm talking about right now.
And Ms. Merida, it would be complete hearsay as to whether or when Ms. Walker moved, what they told the people who signed, where very clearly we have overlapping signatories. That's not, even in an administrative hearing, you need to have the people with actual information, which is why we had our staff testify as to their direct observations. So
no, you're absolutely right. You're absolutely right on that. However, they say, given that, let's hear it anyway.
Okay.
And that's what I would like to do. Given all these factors that Mr. Mandel brings out, I would like to hear what the facts are, and I'm sure the voters of Wisconsin would like to know what the actual facts are, rather than turning down the signatures of almost 4,000 people, not to mention the many people that are throughout the state that are members of the Green Party. And this is by some little tiny technicality that we're going to knock them off the ballot. And we're just getting back to the same thing of why do we always seem to knock African Americans off the ballot?
Please leave your purported concerns for racism out of this discussion. It's offensive to imply that the members of this commission are racist if they decide against.
I'm not saying that the members are. I'm saying that the people that bring the. That there's problems with the people bringing it.
That at the door, please, sir.
Mm-hmm.
Now.
Okay. So, I mean, do you want to? You're saying you want to rule on my objection or not?
I am not going to solicit testimony of hearsay from a campaign representative who elected for whatever reason not to follow the very clear rules of this commission that are not only written down in the statutes. We literally have a manual that says what they need to do. And this is not the person who would be the proper entity to make that claim in any instance. Commissioner Thompson, I believe you indicated you wished to speak.
I had a question for Nate. And it's tied to Dean's question. Your recommendation to sustain the challenge to the 1834, detail that and what needed to be done by the staff to clarify that so we don't have, because Bob's implying that we know something that we don't. So I need to hear it clearly articulated.
Certainly. So it again comes down to burden shifting, I believe. You know, the issue here, then the recommendation could certainly, or would have certainly, I believe, in many cases, probably turned out differently had we had a response, because we would weigh both sides, the complaint and the response. But without the response, looking at the complaint alone, the complaint raised legitimate issues that, in my mind, showed that there were issues with the address on these nomination papers. That based on the complaint, we think it was enough to question them. And there was enough clear and convincing evidence here that there were legitimate problems with addresses on the nomination papers because of what Commissioner or Chair Jacobs was kind of articulating. There were dates that, you had people signing on July 28th or July 29th on the papers that were the TV address, but then they were also signing on those same days on the Royal Street address. That raises the question, well, what is the real address here of the candidate, and was the original address listed of TV correct in the first place? And without the response, that was the kind of the burden shifting here. We believe that they had raised enough, clear and provided enough information with their analysis that we got to the point where, okay, we think the burden has now shifted, that there's a serious question here. Now let's wait for the response. When the response didn't come, we have the complaint to basically look at, and that's how that recommendation came out.
Here's my comment on that. I was fortunate enough to be the chair when we did the recount 2016 at the behest of the Green Party. So we know that they know how to follow it. The rules, Bob. And the fact that you're raising inferences without having the affidavit proof in front. And I think this takes us back to our earlier decision, and Mr. Mendel reminded us that it cost Sullivan a spot on the ballot. And unfortunately, that's why we have the rules, and we're missing a key piece of evidence. Anyway.
Madam Chair, if I may.
No, it's up to the commissioners now. All right, Commissioner.
I'd like to ask Megan a question, if I could.
Just wait, please.
Okay.
Boston, you have not had an opportunity to speak. Would you like to speak?
I think as I kind of ponder this a little bit, we know that the address or the declaration of candidacy does not need to be filed until the signatures are brought in. And when the signatures were brought in, there was a correct address on the declaration of candidacy. But we're not clear when she moved. So I agree with Commissioner Knudsen that when they started circulating nomination papers, the address was correct. So what I don't know is where you draw the line as to when the moving went, because as you said, we don't have anything that stated that she had moved, but we do have the correct address when she filed. So I think that in a sense muddies the water, but I don't know that it makes the other address at the time when circulating began, I don't know that we can determine that they were incorrect. And I guess if you can make that determination that was wrong when it started, because she didn't have to send an address in when she started. And that's what I ponder.
Well, I think that's appreciating that distinction. I think that the issue becomes the challengers made a reasonable argument when they said there's a sworn statement that her address is the second address. And that's under oath, and that is, we assume, completely and absolutely true. We have no idea if the other address is true. For all we know, it could have been a typo that was disseminated by the campaign. And everybody signed the wrong ones for weeks and weeks. And then all of a sudden someone realized it, and then they went and got the other ones. We simply don't know. And so they credibly argued, we have correct ones, we've got a correct affidavit. There's this many of the ones with that one. That's credible. So the burden shifted to the campaign to say, oh, no, sorry about that. Here's the dates on which this would have happened. And then we could do, I suppose, the math, as you're, I think, proposing, Commissioner Bostelman, which is like, what's the date and what's what's before, what's after, what's true, what are the dates, which ones do we throw out? And what we have today, though, is a campaign, and I think Commissioner Thompson's point was very well taken. We have seen a lot of the Green Party's lawyers over the past few years since 2016. This is not a unsophisticated party. They have attorneys. For whatever reason, they chose not to submit a sworn affidavit on this. And while we can hypothesize why not, they just didn't. So we're left with a sworn statement saying something other than what's on those nominating papers is the candidate's residence.
Madam Chair, what presumptions are you making here?
Ms. Merida, you may speak when allowed to, but that is not the time right now. Go ahead, Commissioner Bostelman.
I would just say that as you mentioned, it could have been a typo, and all those TV addresses might have been wrong. Except, why would they have only corrected some of them? I mean, if it was wrong with a typo, they would have corrected all of them, but they only corrected some of them, which leads me to believe that was at the time of the move. So, that's
problem is we have overlapping signatures.
Very few.
Well, enough.
Yeah.
And it's just not before us. We just don't know. And when we don't know, they've sustained their challenge burden. All right.
If I may, Madam Chair.
No, Ms. Merida, this is the opportunity now for the commissioners to ask their questions, and they may do so, but your time to present has already passed. Commissioner Spindell, briefly.
Yes, just a question for Megan. The Green campaign is claiming that they did not get notified appropriately. Apparently, emails lost in the all of us get hundreds of them. And I'm just wondering, was there any attempt to contact these or anybody representative by phone? And if not, maybe in important elections like this, we should adopt a policy where we make sure that the people get the appropriate information and challenge information. Because this situation, as far as I can see, 303,966 people to me, it's intuitively clear when she moved. She moved on the 29th or the 30th. And if we vote on this situation to deny access, then I would sure love you to tell them so we'll all learn in the future, tell the press what the date was that she moved. And that would be, so anyway, that's all I have to say. But also, all the signatories were not
Mr. Spindell, Mr. Thompson is not on the line.
Oh, no, I'm sorry.
So please stop.
I didn't hear you. Okay, we'll stop.
Goodness. I'm going to send him an invite.
We just sent Commissioner Thompson an invite.
Thank you, Jake.
Probably the problem is his signal is not strong enough, and I've found that also in some other Zoom meetings where my Wi-Fi is not enough, and I have to go through the air and some of this stuff. There we go.
Mr. Thompson, are you back?
Get on mute.
Well, actually, just so you know, you were very, very quiet there, Commissioner Thompson. You want to try one more time? Testing.
I'm back.
Okay, much better. Thank you. All right. Commissioner Spindell, is there anything else you wish to add?
Well, I was just talking to Megan, and I don't know if were you on, Mark, when I was asking Megan a question?
I think what you were asking was that going forward.
Bob, I'm sorry.
All right, briefly,
Okay.
Bob, if you want to summarize what you were saying.
Okay, what I was saying is, it appears that there's a lot of miscommunications, at least between what the Green campaign did not receive, and what we all get hundreds of emails every day, and it's we send some and some are never received and so forth and so on. I'm just wondering in the future if we shouldn't have in an important race such as this, in other races, that we have some sort of contact, maybe by phone or whatever, or ask for confirmation of the campaign that they in fact did receive what they needed to receive. Now, one time, if we did not have email going back 76 years, it would have been by paper, and they would have had to come to the downtown to get it, but we found a better way of doing it now. So that was just my suggestion. The second thing, you might have heard this, Mark, I'm saying if we deny the Green Party access, I would sure like the Green Party representative to tell the press what the date was when Angela moved, and also if her first address was a TV address.
All right. Do any other commissioners? Yes, Commissioner Glancy, go ahead. Oh, you're muted.
Oh, got it. Okay. I think it's unfortunate. I think it's something that could easily have been fixed, but unfortunately it wasn't fixed. And I think as a committee or a commission, we have to act on the information filed with us. We can't guess what the actions or what could have happened or what might be correct. I think we have to go on the facts and only the facts. And I find it incredibly interesting that Commissioner Spindell is willing to allow information into this decision when there were thousands of absentee ballots that were obviously in the possession of the post office on time, but because they lacked a postmark, they lacked the proof to allow them to be accepted, that they couldn't be accepted, even though common knowledge would have stated that those ballots were in fact sent back in time. So I don't see how you can apply a more lenient situation or standard to this situation than you do for allowing voters to vote.
I don't see any similarity on that.
Commissioner Thompson.
Yeah, I go back to the recount in 2016. We used an analysis recently on the county executive race where we required details and proof. Mr. Mandel reminded us of that. This is for the President of the United States, President and Vice President of the United States. And it's not our job to follow up, Bob, and send the campaign emails. Okay, if you want to be the President of the United States, you should get it right. And all they have to do is come in here with an affidavit and get it right. We shouldn't be sitting here guessing. And look, it's not my job as the commissioner to do the work for the candidate. And I think if we don't follow the staff recommendations, that's what we're doing. And that's not our job. We don't run the campaigns. We're not responsible for it. We kept people, look at it, we kept someone from running for county exec. That's all. You got to show up and you got to do it right. And I think we have to be consistent. So if I may, I would move the staff's recommendations.
Commissioner Thompson has moved the staff recommendations, which are found on pages, which are found on pages 32 and 33 of our materials. Is there a second?
I'll second.
Commissioner Glancy seconds. Commissioner Knudsen, did you wish to discuss?
Well, I had been trying to gain your attention before we had a motion. I definitely would like to split this motion again because, as I said earlier, I don't agree with the recommended motion number one. What I wanted to say, I can still say, I guess now during debate, if you'll allow me, and that was just that I fear we'll be overturned on this one. I mean, and this goes back to my on the earlier challenges when I said, look, there's two parts today. We're yet to come to the other part. The commission always has to make a decision on whether ballot access is granted. Even if no petitioner came with a complaint, we would make a formal decision about whether or not they had timely filed sufficient signatures. That's a duty of ours. We'll be doing it in a few minutes. If someone disagreed with the way that we operated or commission staff operated, they could file a complaint. We'd hear the complaint and it might go on to court, right? So, I mean, that's a separate part of today. And if that happened, all of the information here would come out. And it very well might come out. So I was just kind of shocked as we introduced this item and we heard from Mr. Mandel, and he quoted to us past precedent in Wisconsin administrative law and so on that said if you miss a deadline now, you have no more right to introduce any new information. And I thought to myself, that's your right. I suspect I couldn't get the votes to overrule you, although I was kind of inclined to try a little while ago. But I mean, there is a presumption of validity, regardless of the fact that they missed the deadline and didn't respond. There's a presumption of validity there that I think is hard to overcome, and they filed a lot of signatures. So I mean, I always hate for us to get overturned, and this one feels like we are very likely to be overturned, because I think we're just kind of putting our head in the sand for what the facts of the case are because of this. And when I say that they could file a complaint, I mean, I'm only hearing dribs and drabs right now of what went on in their conversations with staff, but I have a distinct impression that they thought that it was an either or as to filing the response, or that there'll be a hearing and you could do it at the hearing. And if that was bad information, then so be it. If that can't be introduced as a fact that was actually told to them, I guess that's the case too. But I mean, I can't support the challenge to the number one, sustaining the challenge to the 1834. I don't support that. I think what actually happened here was she lived at that address when they started circulating. It's pretty clear. And I mean, so that's where I'm at. So, I mean, I don't know if you want to do a friendly amendment or you want me to make an amendment motion, but can we divide the question?
I have no problem separating out the questions. Okay.
It's fine with me as well.
So can we do 2 and 3 first?
I move 2 and 3.
I'll second.
Okay. Motions 2 and 3 on page 33 of the materials are before the commission. Is there further discussion on those two motions? Hearing none, I'll call the vote. Commissioner Bostelman?
Aye.
Commissioner Glancy?
Aye.
Aye.
Commissioner Spindell?
Aye.
Commissioner Thompson? Commissioner Thompson? Okay. You'll have to shout a little bit. Your computer is definitely being wonky today.
All right, sorry about that.
There you go. Chair votes aye. So motions 2 and 3 are passed 6-0. Commissioner Thompson, did you want to move? What do you want to move?
I'll move number 1 on the basis we don't have the requisite facts. And so the recommendation by the staff is consistent with our prior rulings, and on something like this, we shouldn't deviate. So I move number 1.
Is there a second?
I'll second.
Motion as to number 1 and a second from Commissioner Glancy. Is there further discussion on this? All right. I will call the vote. Commissioner Bostelman?
No.
Commissioner Glancy?
Aye.
Commissioner Knudsen?
No.
Commissioner Spindell?
No.
Commissioner Thompson?
Aye.
The chair votes aye. The motion fails 3-3. Are there any other motions?
I'll make a motion.
Okay.
Okay. I make a motion that the Wisconsin Green Party be given access to the ballot for the November election.
Motion by Spindell. Is there a second?
I'll second the motion.
There's a motion and a second. Is there further discussion? Hearing none, I'll call the vote.
I have a question. How many valid signatures do we have Mr. Spindell?
From my observations, I'd say it's well above 3,000.
And how are we reaching this number? Just
that's
making
from
it up or what?
my analysis going through it, and I didn't take the time to go through and find it, but there were very few pages that had the same date. And I suppose, as Commissioner Knudsen said, you could move and be at the same place, but very few pages along that line. There were some 1 or 2 pages that I saw, maybe 3, where somebody wrote the new address in and initialed it, but the people had signed before that. These were very, very well done documents. I mean, all the information was filled in 100 times better than the West documents that were presented to us, and very carefully done. And it's there's no question in my mind that there are at least maybe more, but there's at least 3,000 that would be considered valid signatures if you take the address before she moved, those signatures that relate to that, and the address after she moved.
Madam Chair, if I may provide some insight on that question that's before the commission.
Sure.
If we refer to the staff memo on ballot access on page 35, staff, after their facial review, did find 3,737 valid signatures after the facial review. If you factor in the 115 signatures that the commission recommend striking on challenge with motions 2 and 3 that were just passed, I believe that leaves them with 3,622.
No, that's not true.
Actually, we only rejected 57, so it would leave
You're
them
talking about 3,600, right?
Oh, I apologize. I added the 57 and the 58. I apologize for that.
Okay. Anything else, Commissioner Thompson? Does that affect the motion in some way? I want to make sure.
Well, I think, I voted first time, so I'm following the staff recommendation on the burden shifting.
Okay. All right. Commissioner Spindell moved to grant ballot access, which is the reverse of the last motion. Is there further discussion? I will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy. Aye. Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
No.
The chair votes no. The motion fails 3-3.
Madam Chair,
Commissioner Knudsen.
in order to try to break this logjam, I would like to move that we allow the introduction into evidence of the date of the actual move.
I'll second that.
Okay. I will offer my thoughts on that, since I was the one who said that would be improper. The challengers would have no ability to address that in their arguments today, because they would have had no notice of this brand new fact. And Ms. Merida would be only testifying as to hearsay. She has no personal knowledge. She is not Ms. Walker. As I stated before, the obligation to file the verified information was on the candidate who chose not to. And
that's not correct.
That is correct, ma'am. It's not filed, and you need to not interrupt me, please. So I don't think it's fair to sandbag the challengers, which is what we're allowing people to do. We have never allowed I have sat on this commission since it was the GAB. We were present, those of us who started, at the last meeting of the GAB where they approved nominating petitions. That was in 2016. We have never allowed the introduction of ancillary evidence at nominating paper level. We have always required that it be submitted in a verified response, which did not happen here. And I am concerned that we would suddenly change that we have allowed people to rely upon and insisted they rely upon for the entirety of the Elections Commission, and as far as I know, for the GAB before them. So when Attorney Mandel asked if we were going to allow exactly what you're proposing here today, I assured him we were not, because we never have before. It's unfair. He would have a right to respond to it. There's no way he can do it on the fly here, and would be unduly prejudicial to him. So that was my logic in saying no. But I will open it for the discussion of the rest of the commission.
I just have a question. I'm just going to throw it out there. It appears that in the past challenge that we had, the plaintiffs or a Democratic Party or whomever sent investigators to Cody, Wyoming, Illinois, and elsewhere. I'm just wondering if there was, and I would suspect, I don't have any reason to believe this, but I would suspect that maybe somebody sent an investigator to Florence, South Carolina, to make sure that this person lived in one place first and then lived in the second place second on approximately the date of the move. Now, if somebody were to introduce that type of information, I think that would be very interesting.
Well, we actually prohibited Attorney Mandel from filing those kinds of responses. We recall that from the previous challenges, is he wanted to submit reply briefs with supplemental affidavits, and we prohibited him from doing that based on all the different reasons we recited earlier.
Well, you know, that's
even if he wanted to bring it in,
mm-hmm.
I'm not sure he would be able to do that because we told him he couldn't. So if we told him he couldn't on that challenge and everybody agreed on that point of order, I'm not certain why we would change that exact position to benefit Ms. Merida or Ms. Walker, rather. So,
well, maybe to go along with Commissioner Knutsen's motion, that part of it should be that after, if she were to give us this information, then Mr. Mandel could reply with any information that he currently has or has found out or reports or whatever, which is sort of even it out.
How would he do that when he wouldn't know what she's going to say until this very moment?
Well, I would suspect...
We have a ballot deadline of September 1st. People have to print their ballots in, like...
No, I understand that. But I'm pretty sure that the answers to all these questions are extremely obvious. And again, that's from my going through every single page of this and reading all this stuff. The answer is very, very obvious here. It's not like it's some strange thing, unless, as Commissioner Knutsen said, there is no such address as TV, or that she never lived there. And I think the representative from this could tell it if that would make a difference. Now, probably, given what's being said, even if things came out to be that she actually did move and so forth and so on, the way that we're sort of doing that is we're saying, well, that can't be provided. So, I think probably what we have here is we have a 3-3 split, and I'm not quite sure what happens from there, but maybe this is an issue that needs to go to court.
Okay. Would any other commissioners like to be heard on that? Commissioner Glancy.
I just, one of the things that could have been done to prevent this is Ms. Merida had indicated that there were a lot of more signatures that they didn't file. And yet looking at the information that was sent to us, they didn't file any supplemental nomination papers. So if they had done that, it's not really a question, but if they had filed supplemental papers, perhaps those supplemental papers would have contained enough signatures with her current address to allow them ballot access. So they've had a number of opportunities. And I continue to be amazed at our willingness, or some members' willingness, to accept what they think probably happened, or what they're assuming was her correct address, although we have no proof of what her correct address was before the address she put on her declaration of candidacy, and you're willing to just accept this information as fact and act on it when in fact, when we've never done that for anyone else before.
This is your process.
Ma'am, you may speak when you are addressed. Otherwise, I will disconnect you from this call and you'll have to watch it on Wisconsin Eye. Are we clear? Thank you. Do any other...
I could just maybe answer the commissioner's point. As I understand, they presented 3,966 signatures. I believe that you're only allowed to present 4,000. So maybe that's the reason that they did not present more than the almost 4,000 signatures.
Well, if you remember, Commissioner Spindell, we have ruled that we will allow people to file more. We just don't look at them unless there's a challenge to them and striking of other signatures. And then we do look at the excess. So in fact, they can file a whole lot of signatures. We just don't look at the supplemental ones unless there is a challenge to the underlying ones that requires us to look at them. So that's actually not correct. We've
okay.
Doing that was the ruling in 2016 involving, I believe it was candidate Young, Leon Young. I think it was Leon Todd, Leon
Young. I think that's fine. And I think
that was
we as
actually litigated to the circuit court and sustained by the Court of Appeals.
Right. I think that maybe we as commissioners don't need to go forever in terms of what the Wisconsin Election Board did, what the GAB did. I think we should take a look at what best serves the people and the candidates and the voters of the state of Wisconsin and not be tied into what the GAB has done over the many, many years. So that's another subject for another day, but I think this is something we should be looking at.
Do other commissioners wish to be heard on this?
I'm trying to understand what the motion is. Are you asking, Dean, that we have open the doors to hearsay and procedure, and that's where we're going now? I mean, we don't have. What's troubling to me is you have a very sophisticated campaign that knows the rules, knows that an affidavit could cure it, that you could file, as Commissioner Glancy said, you could have supplemental signatures. And I'm trying to find out why we're being asked to do the campaign's job and save them based on hearsay. But help me out on that.
The question was for me. Well, first of all, I mean, I don't think it's fair for us to, judge or sort of prejudge based on what a party's representatives did in past years. You have all different individuals and so on. I mean, that's not really fair. I think everybody needs to get a fair shake. And that's all I'm getting at here is, I mean, I wasn't asking that we introduce hearsay. I was asking that we be allowed to know the date that the vice presidential candidate Angela Walker moved, because that's the crux of this one.
And my question to you is how are we going to get that?
Without it being hearsay.
Well, I would suspect that the campaign manager would know that, so it's not hearsay.
It would be hearsay.
Well, are you saying the only person that can swear to when a move of residence happened is the resident themselves?
Or their attorney, right?
No, their attorney can't do it either.
No.
I mean, I suppose potentially if they were physically present when the new lease was signed. But if it's nothing more than she told me she moved on Thursday, that's hearsay. Or she told me she moved on Tuesday or whatever.
But even though that wouldn't be part of the record, and realizing that it's hearsay, we could still allow that, realizing that that's not the official part of the record.
Well,
being an administrative body,
what we put into it, and what you're asking is to introduce evidence that we don't allow under other circumstances. We didn't even allow our own staff to have hearsay today. We required them to testify. We didn't even accept them. So
I'm not saying we accept the hearsay. I'm just saying that we have the hearsay, and it's not be being part of the record. Perhaps that's.
Well, Madam Chair,
I don't know. I don't want to talk. Go ahead. I'm sorry.
Commissioner Knudsen, go ahead.
Are you suggesting that if we had Angela Walker herself zoom in and testify to us when she moved, that you'd accept that to break the logjam?
No, I'm not
So
suggesting.
it isn't really about who's giving us the information then.
It's
really.
It's one of the reasons, but the real reason is we have a procedure. We literally kicked people off the ballot for county executive for a completely unknowing violation of these rules. We have a challenge. No response was filed. And to suddenly be like, well, let's wing it is unfair to all of the other candidates who followed the rules. They didn't. And they want to be president. So, Mr. Judnick wishes to speak. Go ahead.
In an effort to hopefully maybe break a logjam like Commissioner Knudsen attempted, would it be helpful for the commission to consider whether the information that was provided through the complaint, so now we're dealing with information that is in fact in the record, take a vote on whether they believe on, basically the information in motion 1, whether they believe that the complainant actually presented enough clear and convincing evidence to shift the burden. And the reason I ask that is that recommendation is based on essentially staff's review of the information. But if the commission does not agree with that, then I think that changes things, because then at that point, then the burden on that point is not shifted to the respondent for a response. So we're dealing with, okay, there is no response, but if that burden did not shift, then she doesn't have to respond. So in an effort to kind of talk that through, maybe the commission could make a finding as to whether they believe there is clear, convincing evidence that she, did not live at 3204 TV Road when those nomination papers were circulated.
Well,
just a thought.
I appreciate that, but I doubt that's going to move this needle. But
I understand. I'm just trying to help.
Well, Madam Chair, we do have a motion on the floor right now, and that was to allow evidence. We haven't yet voted on that one.
That's
true. That was my motion.
Are you calling the vote?
Well, no, but I'm pointing out that I think Mr. Judnick just more elegantly and eloquently, I should have to say, and with his legal background, and I can't say what he just said, but that's what I've been trying to tell you all is I don't find clear and convincing evidence as to motion number 1. That's what I've been trying to say is I don't think there is clear and convincing evidence there. In fact, I think if we had just one little piece of factual information, I'd flip all of you that are currently saying based on just purely procedural things that, hey, they have a presumption of validity. We got to go with that. And there's more than enough signatures here. And I don't know how to break the logjam any other way. I mean, I think Nate, I could withdraw my motion and we could have a motion about findings. My motion in that case will be no, a finding that there isn't clear and convincing evidence on the 1,834 signatures. But we still have this one to deal with, which I think is a reasonable thing to ask in this circumstance. It's pretty reasonable.
The problem I have is it violates everything we have ever done in every single previous hearing we've ever had on nominating papers. And to make a special exception for a party that decided not to follow the rules for reasons I have no understanding of, prejudices the challenger, who we just, good Lord, now several hours ago, literally told couldn't do the same thing in a different hearing. And so what I'm suggesting is we have a duty, and people have a due process right for us to be consistent. And we're really actually supposed to be consistent in these things. And so I think we have to be consistent. I also think it's consistent with the statutes, which is challenger, response, verified.
Madam Chair, may I make a point of order?
Go ahead, Mr. Mandel.
Yes, thank you. I just want to note that with respect, I think that Mr. Judnick and Commissioner Knudsen might be framing the question incorrectly. The complaint doesn't say anything about anybody moving. The complaint says that the address on several of the nominating papers does not match the address on the declaration of candidacy. The question, it seems to me, and I defer to the commission, but it seems to me the question should be, have we presented clear and convincing evidence that that is true? If so, the explanation, the burden shifts to the other side. I don't think it's fair to put on us. We never mentioned the concept of anybody moving their residence. We just mentioned that the addresses did not align. I don't think it's fair to put on us the burden of proving whether or not Ms. Walker moved. That's my point. Thank you.
No, and that was the reason why I made the initial motion, Dean. And I mean, look, people got to do it right. They didn't do it right.
If I may.
Ms. Merida, you may briefly respond, but only to Mr. Mandel's point of order and to nothing else.
Mm-hmm. Well, you'll have to correct me. I'm sure that you will. The fact of the matter is that your statute does not specify either way. What it doesn't call for an affidavit. It's silent on what happens when a candidate changes address. I mean, that's a matter of that. That's the fact. Your staff did not ask for an affidavit, and really, they received an affidavit when we filed the declaration of candidacy, notarized with the current address. We can only do what is required of us.
Okay, thank you, Ms. Merida.
Okay, can I?
Yes.
To the point of order, because I take it you're going to have us vote on that one.
I suppose we have to.
So I believe a candidate could live at address A and start circulating papers, and the header would say address A, and they could move to address B, and they could circulate some living at address B, and they could move again to address C and have some like that. And then when it came time to the deadline to file the declaration of candidacy, I'm guessing they would be completely in the right to file where the currently lived at the date of that declaration, which would be address C. And I don't think that invalidates the signatures at address A and address B. Now, I'll grant you the thing about crossing out the header and everything, there's a lot of confusion. But we're no longer talking about those. We're talking about a clean set of papers that had address A on it. And the only missing piece of information here is, when did you move? There was no requirement that there be an early declaration of candidacy. I don't believe there is. We haven't been corrected by Mr. Judnick that, I mean, do you have to file a declaration of candidacy before circulating papers? I don't think so.
You do not.
No, because
You're
actual
correct.
citizens could nominate someone who hasn't even decided yet whether they'd be willing to do it if they were nominated. And then at the end, the candidate looks it all over and can say, yeah, I'll do that. I declare my candidacy. That's the order of this. It's pretty common in nomination processes that, hey, people can be nominated and they haven't necessarily jumped all in yet. I believe what our law says is you have to file a declaration of candidacy probably before you spend money, or spend money over a certain amount. But I'm not sure that that's happened yet. And that's not our bailiwick anyway. So what I'm trying to get at is, I'm still swinging the bat to try to convince, to get us to a majority that, hey, don't be fooled by that declaration of candidacy part, because there was no requirement that there be one for address A, only that there be one at the end. And so
but I don't think that's really what the argument is. The argument is that had there not been a challenge, staff would have accepted the signatures. However, there is a challenge that says the candidate under oath has sworn they live elsewhere. There's a sworn statement under oath that says they live somewhere else than on those nominating papers. They have shifted the burden to say, hey, you have sworn that you live somewhere that's not on the papers. So now that presumptively means that the papers are wrong because you swore you lived somewhere else. So now the burden shifts back to the candidate to say, sorry, you're right. Let me clarify. I had 2 addresses or 3 addresses or however many in your hypothetical they had. But when someone swears under oath they live in one place and they submit papers that say they live somewhere else, the burden has shifted to them to show that the somewhere else is also where they live.
But Chairman Jacobs, that's exactly my point. The burden didn't shift. There was no burden shift there. They had no obligation to disclose that first address, only that it be accurate at the time that in the papers and the papers as they are being signed. That was their burden. I don't think there's clear and convincing evidence they didn't do that right. They've got loads, hundreds of thousands.
We know that she's sworn she lived somewhere else. Like if she had gone into a deposition and said, completely unrelated to the Elections Commission, I live somewhere else, that would also be a valid reason to challenge the papers. So she said, I don't live at the address on my nominating papers. She's literally sworn that under oath. That's enough for a challenge because the challengers are saying she swore under oath she doesn't live at that address on her nominating papers. All she had to do was do exactly what you just said, which is swear under oath, I did, and I moved. But she didn't.
And all I'm saying is because we have a longstanding presumption of validity, that we have to presume that it was accurate. And in fact, the burden shift hasn't happened, and that presumption still carries the day unless there's evidence to the contrary, of which it's not in place here. So there was no burden shift. We have to presume that she lived there. And I think that with a little bit of an investigation, we would find out that that is exactly what happened.
Well, but that's not on us, it's on her. That's not on us. It is on the candidate to do exactly that. And not on us to go like search out her obligations. And the thing is, where you and I disagree is, it's not that the declaration of candidacy didn't have to be filed. It's that the evidence in front of this commission, the only verified evidence is her sworn statement under oath that she did not live at the addresses on the nominating papers. She might have, but she has sworn under oath that she doesn't. Literally sworn under oath. I live somewhere else. That's enough to burden shift and go back to the other side to say, okay, now you got to prove that you did. And for some reason, she didn't do that. So whether it was a declaration of candidacy, an affidavit in a small claims case, a deposition in a divorce, it would have been a sworn statement under oath that she lives somewhere other than her nominating papers. That's more than enough to shift it over to her to answer the next step, which is, but I actually did.
Well, I think, I'll let others speak, but I mean, to that last part, our declaration of candidacy form is a fill in the blanks form. It doesn't have place for tell all the nitty gritty details of, well, where did you live before that and where did you live before that? It doesn't contemplate that. It is a where do you live at this moment in time?
Yeah.
And it doesn't do anything to dispute the fact that you may have lived somewhere else. It doesn't invalidate those papers. It does not invalidate those papers because you can live at address A and not be obligated to file a declaration of candidacy at address A.
But she hasn't sworn she ever lived at address A. She swore she lived at address B and only has sworn she lived at address B. That's what I'm saying. I agree with you. If she had filed something that said I lived at A and I moved, none of this discussion happens. But she didn't for some reason. And I don't know what that reason is. Commissioner Thompson, I think you were looking to speak.
My position is I voted with the staff recommendation. I think it was consistent with what we did in February when we didn't let Mr. Sullivan on the ballot. I don't see this any different. I think the campaign, it was their burden to do it, not ours. And let's just take the votes and get on with it. Some court's going to decide this. The sooner the better.
Okay. Commissioner Glancy, did you want to be heard? Whoop, you muted yourself and said
I'm good, I think. Okay. I think the presumption of validity is what we do when we look at them, okay? But now we have a challenge to that presumption. And I think it's our responsibility to say, does he have a point with this? Has he supplied proof that we shouldn't accept these on their face value? And he points to the Declaration of Candidacy, which lists a different sworn address than the nomination papers. So what we're saying is, yes, he has a point. They don't match. And I think that for us to bring any other information or guesses into why they don't match is beyond the scope of what we need to do here. Does he have a point? Did he meet the burden of proof that the address on the nomination papers may not be her current address? And I believe he has. I don't think we can extrapolate any other additional information. He had the opportunity to file a statement at that point saying that this was my address at the time I circulated these nomination papers. And yes, her declaration of candidacy did not need to have a litany of all the places that she's ever lived. But they have brought up something here which calls their nomination papers into question. And our decision today is whether or not they have done that. Have they called them into question? We have no information that we can rely on other than supposition as to whether or not she lived at that address beforehand. He has, in my opinion, met his burden of suspicion that her nomination papers may be invalid.
Thank you. Commissioner Bostelman, do you have any desire to be heard on this? I want to make sure you have.
I think basically what I said before is kind of the way I feel.
Okay. Is there further discussion on the, I believe it was Commissioner Knudsen's motion to have some sort of testimony? Is that correct? That's what's on the table right now?
Was there a second to that?
I think I second if you needed it.
They'll second it. All right. Is that the correct motion on the table? Yes? Okay.
I asked for specific testimony just as to the date of the move.
Okay. For specific testimony as to the date of the move, which assumes there was a move. So we will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
No.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
No.
Commissioner Jacobs votes no. The motion fails 3-3.
So then we're
Madam
back
Chair?
to my motion then, or?
Can I make a new motion?
Sure.
Sure.
I move that the commission certifies 1,789 signatures for candidate Howie Hawkins and candidate Angela Walker for the November 2020 general election, and that the commission deadlocks as to the validity of another 1,834 signatures based on insufficient evidence as to where the candidate lived at the time of the circulation of the signatures.
Okay. The motion is to certify for the Green Party and candidates Hawken and Walker 1,789 signatures, and that the commission stipulate that there is no finding as to 1,834.
34.
Is that correct?
Correct.
Okay, that is the motion. Is there a second?
I'll second.
Okay.
For discussion, I'm sorry. I guess I don't understand the motion. Dean, could you explain that a little bit more? You're saying that we're going to say that 1,700 are correct, but we can't come up with any idea on the other, whatever it needs to be, the other, I don't know, 2,000 or whatever it is.
Well,
we're not going to come up with that, so we're not going to vote today on whether or not they should be. You're saying we should not, the information we have, we should not place them on the ballot.
Well, I've tried.
I think we need to have a clear yes or no. Are we going to put them on the ballot, or aren't we going to put them on the ballot? I think we need to go around in circles like this. Say it again.
I think under.
Or did we already do my motion on that?
Yeah, we already did. Under Dean's motion, by function of law, they would not be placed on the ballot, but they would then have the right to immediately appeal the finding of the commission to the court. Is that correct?
Well, they would have that anyway, right?
Yeah.
Well,
they would have that anyway, even if we deadlocked on the 3-3. I think it's so obvious. We all know what the correct answer is. What is right on this thing, and we also know that the 3,600 or whatever signers were not, they did not sign in error. They when they signed, they knew what the address is, or at least we presume to have that. We can't put any information into this thing in terms of what the actual is. I think we should either have up and down vote.
We've already done that.
Yeah, twice.
Okay. But why don't we just leave it at that? Why do we want to continue this situation? Why do we want to continue trying to do this? What's the purpose of that?
I think there's a good purpose. You seconded the vote. I'm going to support the motion. It narrows the issues. It goes immediately to the court to address one question, is whether or not on the 1834 the staff recommendation was right or Dean's theory is right. And if Mr. Sullivan's case isn't instructive and dispositive, somebody will tell us. So I can support the motion, Mr. Knudsen.
Okay, and could I ask the two representatives what their thoughts are on that particular motion?
No.
Sure. Well, can I speak to my motion?
You absolutely may speak to your motion.
The reason I'm making this motion, and I think I've made it abundantly clear, that I believe that there are 3,680 ballot signatures or something close to that. And if we knew a little bit more, it would be pretty clear that there's more than enough signatures here. But I can't get consensus on that. But we do have unanimous consensus on the 1,789. So that's the reason for the first part of the motion, is just to let any future court know that this body was unanimous in the 1,789. And so, as Commissioner Thompson said, I'm trying to narrow the issue. And the issue is that 1,834 that I started talking about 2 hours ago when I said I don't find clear and convincing evidence that there's a big problem with those, because they had a clear header, and I think they have to be presumed valid until proven otherwise. And I don't see any proof at all. They could have brought proof. They could have sent an investigator, somebody that had said, oh yeah, I remember seeing the moving truck there. I know exactly when she moved, something. But there was no evidence about when the move happened. So I don't think burden shifting happened over to the campaign. I think the campaign could still cruise by here on their presumption of validity. And I suspect when this gets to court, that's probably exactly what will happen. So what I'm trying to do is get to narrow down to the issue, to leave a record for future litigation. Because if we deadlock today, and we've already deadlocked 2 times, and I think we could vote it, Bob, as many times as you want to, and I get the strong impression we'd deadlock as many times as you want to do it. For me, twice is usually enough. And then it's time to move on. So this is a way to move on. And I think it moves on, leaving the candidate in a stronger position for future appeal if she would want to, because it does lay down the fact that, hey, we were all unanimous on the 1,789. So
would you accept a friendly amendment?
Well, I have to hear it first.
Okay, let me put it through. That on your amendment that we accept that number, and on the remaining 2,000 or whatever, the commission was deadlocked 3-3.
Yeah, that's what I said.
Literally what the motion was.
No, but I mean the motion actually states that the motion act, not that, that it happened.
I will read the motion. I will read the motion again.
Okay.
The motion was that the Elections Commission moved to certify 1,789 signatures. That the commission shall reflect that the commission has deadlocked on certification of 1,834 remaining signatures. That's the motion.
Okay.
Actually, I had a little bit more. I don't remember my exact words, but that we deadlocked on those due to insufficient evidence as to when she moved or whether she lived there. I don't remember exactly what I said.
Well, let's include that in the motion.
I have the language.
You have my exact language?
Move certify 1,789 signatures for Holly Hawkins and Angela, I'm sorry, I can't remember the last name, Walker, and that the commission deadlocked as to the validity of another 1,834 signatures based on insufficient evidence as to where the candidate lived at the time of circulation of the nomination papers.
Okay, would it be of the do we have to put the specific address on what do those 2,000 apply to? Do they apply to the Royal? I guess they apply to the Royal, right? Which ones are we questioning?
Is there a reason we're complicating this, or
well, which ones are we approving? The TV or the Royal? Can somebody clarify that?
I believe we're invalidating the TV road address.
We're invalidating?
We're not invalidating anything because we haven't come to enough votes to invalidate.
Okay, so what you're saying, the Royal is the one that we're voting and saying those should be counted. Is that right?
No, in motion number 1, the 1,834 apply to the 3204 TV road address. It was cleanly on the header of all of those. So there was no changing or anything like that. And we aren't saying they're invalid. We're saying that we've deadlocked on whether there's clear and convincing evidence that they're invalid.
Okay, well, I think you're right that it says at the top the TV address, but in the other ones it says at the top the Royal address. So it wasn't like there's a whole bunch of Royal TV crossed out and the Royal ones were added. The Royal ones were printed on actual certificates to meet that number that was mentioned. Now, does that clarify for you, Dean? What it's not that we have hundreds of pages that it was the TV address was crossed out and the new address was put in.
Right. None of what we're talking about in this has anything to do with that.
Okay, so we're talking about we're saying that the TV addresses are okay. No, we're saying the TV addresses are not okay and the Royal addresses are okay. Is that what we're saying?
No, we're just saying what we're going to vote on Dean's motion.
Well, I'm just trying to clarify what it is.
Right.
Decide.
I will give an attempt to clarify this. That the motion is to certify 1,789 signatures represented at the, which represent signatures showing the 315 Royal Street, Apartment A, Florence, South Carolina address, and that the commission agrees that it has deadlocked on the remaining 1,834 signatures reflecting an address of 3204 TV Road due to insufficient evidence as to the residence of the candidate at that address. Dean,
And the moving date. I think he had it on the moving date.
Stop. Dean, is that a correct recitation of your motion?
He had moving date.
What I heard from reading back sounded exactly like what I had said. So,
well, what I added was which addresses we were certifying.
And so, as to the first part of your address addition, yes, that we have all agreed on 1,789 signatures using the 315 Royal address. And as to the second part, there are 1,834 petitions, nomination papers that have that TV Road address at the top of them. And what we are deadlocked on is whether there's clear and convincing evidence that those are all invalid. That's what we're deadlocked on. That's what the judge would be ruling on.
But wouldn't you say about the moving date and if she really looked at that address? I'm just asking him as a clarification.
Well, that's what I was trying to say when I said that we had insufficient evidence as to where she moved. The reason is it's pretty apparent to all of us that she moved at some point. And like I've been trying to get out, we don't know when. So we can't determine what proportion of those may or may not be invalid. But I don't think there's clear and convincing evidence that they're all invalid.
There's also no clear and convincing evidence that she moved. We're supposing that, but we have no evidence of that.
Right. The only evidence in the record on the fact that she moved comes from our own staff, which I guess we could put them under oath and have them testify about all the emails that they exchanged back and forth about her move. So it's kind of ridiculous to keep talking about, well, we don't know that she moved. She moved.
Well, maybe we should do that.
Okay, so can we go back to the motion? Because otherwise we're going to be here all night. We already have been, and we're tired and crabby. So I want to make sure, Dean, that I'm going to recite the correct motion. Move to certify 1,789 signatures, which are signed on pages showing the 315 Royal Street address. That the commission stipulates that it has deadlocked on all remaining 1,834 addresses due to insufficient evidence as to the residence of the candidate.
And the date of the move.
Bob, that wasn't his motion. Would you?
Yes, it was. It was the way it was read back. That's the way it was read back.
Bob, it was
read back. Yes, the guy read it back. Who had it? Read it back. Read it to us.
Read it back, please.
Just a second. Let me go. I got to scroll back up and find it.
While Reed's looking, did you say 1,834?
Correct.
Okay, I thought you said something different.
Commissioner Knudsen's original motion was he moved that we certify 1,789 signatures for the Green Party candidates, and that the commission is deadlocked as to the validity of another 1,834 signatures based on insufficient evidence as to where the candidate lived at the time of circulation of the nomination papers.
I'm writing it down. Lived at the time of circulation.
And I move that we take a vote on that motion.
All right, the vote has been called. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
Chair votes aye. That carries 6-0. All right. Do we want to soldier on and take our break before closed session?
Or you want to get through by the time of the speech, don't we? You know.
We do
least
still
I do.
also have to consider the other ballot access questions. So for some of the
soldiering on part.
Okay.
What page is that?
That's page 34. As a part of our work as a commission, in addition to the challenges, we do have to certify the other candidates who were not challenged and who were determined by staff to have turned in their papers. The recommendations are set forth and the motion is set forth on page 36. The staff is recommending that we make findings. Nate, do we have to make the findings or can we just do the motions? Nate? You're muted.
I know. Can you hear me now?
Yes.
I'm having problems with my headset. I just decided to die. So sorry. So what was the question? I'm sorry.
I think we
Do we
only
make
have.
the factual findings or do we just need to address the motions? Because motion number 1 addresses approving the Libertarian and the American Solidarity Party. Motion number 2 is denying access for the American Independent Party. And then as to 3 and 4, we already addressed those previous, or actually as to 3, we addressed that previously, but number 4, we would have to rule on, correct?
No, 4 is, we just decided 4.
Well, we actually have to make the ruling that they are therefore denied the access. We did not have that as part of the
That's
motion.
not going to
Okay.
happen.
All right, that didn't happen.
Madam Chair, I'd like to make a motion.
Go ahead, Commissioner Knudsen.
Okay, I would like to move that the commission finds that Joe Jorgensen and Jeremy Cohen as independent candidates representing the Libertarian Party should be certified for ballot access, and therefore the commission approves ballot access for Joe Jorgensen and Jeremy Cohen representing the Libertarian Party.
Is there a second?
A second.
Is there any discussion? All right, call the vote. Commissioner Bosselman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
Chair votes aye. They are placed on the ballot. You want to do the next one, Dean?
Yes. I move that the commission finds that Brian Carroll and Amar Patel as independent candidates representing the American Solidarity Party should be granted certified for ballot access as independent candidates for president and vice president, and that therefore the commission approves ballot access for Brian Carroll and Amar Patel representing the American Solidarity Party.
Is there a second?
I'll second.
Any discussion? Call the vote on that. Commissioner Bosselman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
Commissioner Jacobs votes aye. Carries 6-0.
Madam Chair,
Go ahead.
I move that the commission finds that Kyle Keeley Kopepke and Taya Yvonne should not be certified for ballot access as independent candidates for president and vice president representing the American Independent Party, and therefore the commission denies ballot access for Kyle Keeley Kopepke and Taya Yvonne.
Is there a second?
I'll second.
I'll second.
Is there any discussion? Call the vote. Commissioner Bosselman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
And the chair votes aye. That carries 6-0.
Now,
I'm going to move that based upon a certification of less than 2,000 signatures, that by operation of statute, the Green Party candidates Howie Hawken and Angela Walker shall not be placed on the ballot by the Elections Commission.
I'll second.
Discussion. I think we have to do something that they can appeal. And I think I was trying to phrase the motion as it being a function of law and not a finding of the commission. Dean, if there's a modification to that you want, I'm open to it, but we got to give them something to appeal.
Well, you got to give us something we can vote for.
I just did. I said, based upon a certification of 1,000, what the heck was it? Okay. How about this? Based upon a certification of 1,789 signatures.
Plus another 1,834 that shall be presumed valid.
No, come on.
But the commission cannot agree on their validity. How's that?
Well, why don't I make a friendly amendment to this? That we just substitute. Okay, I'm sorry. I would like to make a friendly amendment that might make it very easy.
How about I figure it out first? Okay.
I can make it very easy for you.
Based upon the certification of 1,789 signatures, and based upon the fact that the commission has deadlocked on an additional 1,834, the commission finds that by operation of law, the Green Party candidates of Howie Hawkins and Angela Walker shall not be placed upon the ballot.
I'd like to make a friendly amendment. Can I do that? You don't have to take it, obviously, but I'd like to make a friendly motion that we substitute the motion that we already passed.
A minute, Bob.
Yeah. I thought you said I could. I'm sorry.
No.
Okay.
Just wait. Dean?
Well, let's vote on it.
All
They're
right.
going to get to appeal whether it passes or not. They may.
Here.
Yeah.
I'll second it. Here's the discussion. We've deadlocked. We've laid out the basis. Because we don't have enough votes as a matter of law, by operation of law, they're denied ballot access. That gives them the immediate thing. We're not going to agree on this presumption. I went along with the staff recommendation that the candidate didn't have enough. I don't want to revisit that whole thing. But the 3-3 vote, as a matter of law, denies them access, and that's what they need. So
I get that. So
okay.
Ann's motion may not pass, and because it doesn't pass, they'll have the right to appeal.
That's right.
Okay. Well, then we don't even need it.
That's my point. Yep.
You don't want to give them a final order?
Let's substitute our last motion for this.
Do we agree that a 3-3 vote doesn't get them on the ballot? I think we do, right? You need 4 votes to get on the ballot.
That's what I'm trying to just, by function of law, they're not placed on the ballot, and that it's not the vote of the commission one way or another. It's just the way the law is. And then they've got a final order, and they can do with it what they want. That's why Nate has both the challenge motions and these motions here.
Let's just substitute the last motion we passed for this one, instead of going through all this again and what the wording may be or not be and so forth and so on.
I think we need to know whether they're granted ballot access or not. That's the decision, and that is what's appealed. I think the commission, from my opinion, they need to decide whether they're granting ballot access or they're not. I understand the hesitation to do that, but I think you might create additional problems here, on appeal if there isn't some sort of decision of the commission with 4 votes that says whether they're on or not. That would just be. I don't think there's a default, right? The commission have to decide the ballot access. That's their statutory obligation to do that. So I don't know how to get there, but I think that is the advice that I would provide, the unsolicited advice that I'm providing now.
Okay. Would have been nice if you'd have provided that back when we were discussing if we'd introduced more facts that might have helped break the logjam. I mean, right? Well, why don't we take a vote on the motion to deny, and why don't we take a vote on the motion to approve? I think we'll have a pretty close record for any judge to look at of what went on here.
Yeah, I would agree with that.
Well, how can we vote to approve if there's only 1,789 signatures? I mean, that's what I'm saying is, like, by force of law, if we've only certified 1,789 signatures, we can't put them on the ballot anymore. Like we actually would not be allowed to do that.
Might I
go ahead
address that?
Sure.
So I think the rules now are quite a bit different for this part under page 34 and through 36. Because under the challenge, we had all our administrative rules about challenge procedures. But now it just comes down to us deciding if they turned in enough signatures. I don't understand why we can't do whatever we need to do to decide whether there are enough signatures. We don't have all those rules about challenge and response and all of that. Now it's just the 6 of us sitting there with a pile of nomination papers, and we're trying to figure out if these are valid or not. And I think they are. I think they clearly are. More than enough.
But you're not going to get people to agree to put them on. You've gotten an agreement that there's a certain number that are approved.
But yours was a procedural opposition to it. You were opposed on the process. They missed a deadline, therefore you cannot clarify the record here. But for this page 34 to 36, none of that applies.
That's not true, because
No,
but here, look at it. I can't presume they're valid when the staff recommendation is that they aren't valid. That's it. Right? 1,834 votes that the candidate didn't fail to show up. Mr. Sullivan didn't even know about it. Candidate here knew. Candidate could have solved any problems they wanted. All
right. So we're going to beat a dead horse. We're going to have a 3-3 vote apparently on my motion. We'll have a 3-3 vote on yours. And then what?
And the judge will...
Can we move on to the next subject?
All right. We'll call the question. The motion was that based upon the certification of 1,789 votes or signatures and upon the deadlock of the commission by operation of law, candidates Hawkins and Walker for the Green Party are denied ballot access. That was the motion. All right. Call the vote. Bostelman.
No.
Glancy.
Aye.
I vote no.
Sandell.
No.
Thompson.
Aye.
Chair votes aye. Motion fails. Go ahead and make yours, Dean.
Okay, I'd like to move that the commission finds that candidates Howie Hawkins and Angela Walker have filed sufficient nomination paper signatures and should be certified ballot access as independent candidates representing the Green Party for the offices of President and Vice President, and that the commission approves ballot access for Howie Hawkins and Angela Walker.
Okay, there's a motion. Is there a second?
I second.
Okay, I'm going to call the roll. Commissioner Bostelman.
Madam Chair.
Yes.
I'm sorry, just for the record, I just want to note that on behalf of the complainant, we object to this. That's all. Thank you.
Okay. All right, Commissioner Bostelman votes aye. Commissioner Glancy.
No.
Commissioner Knudsen,
Aye.
Commissioner Spindell,
Aye.
Commissioner Thompson.
No.
Chair votes no. The motion fails 3-3. The commission has failed to take any action to place or has failed to vote to place them on the ballot.